Committee on Education and Labor will come to order. Everyone is welcomed. I note a quorum is present. And note for the committee that Congressman Jamie Raskin of Maryland, Congresswoman Sylvia Garcia of Texas, and Congressman Steve Cohen of Tennessee, who chairs the Subcommittee on Constitution and the Judiciary Committee, will be participating in today's hearing with the understanding that their questions will come only after all members of the committee on both sides of the aisle who are present have had the opportunity to question witnesses. The committee is meeting today in a legislative hearing to hear testimony on Do Not Harm, the misapplication of the Religious Freedom Restoration Act, or RFRA. Pursuant to Committee Rule 7, opening statements are limited to the chair and ranking member. This allows us to hear from our witnesses sooner and provides all members with adequate time to ask questions. I recognize myself now for the purpose of an opening statement. 78 years ago today, President Franklin D. Roosevelt signed Executive Order 8802, the first action to promote equal opportunity and prohibit employment discrimination in federal contracting in the United States. The order barred private defense-related contractors from discrimination and it required certain defense-related programs to be administered without discrimination as to race, creed, color, or national origin. Subsequent orders and amendments have been signed and have confirmed the principle that discrimination is prohibited when using federal money. Against this backdrop, we examine the challenge of protecting our civil rights while maintaining our fundamental commitment to religious liberty. Religious liberty is a fundamental American value. Our founding fathers knew from personal experience the dangers of governmental entanglement with religion. In 1779, Thomas Jefferson, in my home state of Virginia, introduced and helped pass the nation's precursor to the First Amendment, which states, "Our civil rights have no dependence on our religious opinions any more than our opinions on physics and geometry." The Virginia Statute on Religious Freedom became the foundation for our First Amendment to our nation's Constitution, which stipulates that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The First Amendment makes clear that all Americans have the right to practice the religion of their choice, or none at all, and reflects our country's commitment to separating religion from government or church and state. Religion has played a vital role in our nation's history. It has furthered social justice causes, such as the abolition movement, civil rights movement, and the movement in child labor. However, some have used religion as a pawn to justify slavery, Jim Crow, and the slaughter of our native populations and other horrific acts. In fact, when I was growing up, segregation was preached from the pulpit. Before the Supreme Court struck down the ban on interracial marriage in Loving v. Virginia, the judge in the circuit court in Virginia, the state court, in a 1965 lower court decision, relied on his own religious beliefs to conclude, and I quote from his opinion, "Almighty God created the races, white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with this arrangement, there would be no cause for such a marriage. In fact, the fact that he separated the races showed that he did not intend for the races to mix. That was the basis for the original decision in Loving v. Virginia that was overturned by the Supreme Court. And while some religions have been protected in the courts, others have experienced less or sometimes no protection at all. In 1990, the Supreme Court's decision in Employment Division v. Smith upheld the firing of 2 Native American employees for participating in ceremonial peyote smoking during personal time. In response, Congress passed the Religious Freedom Restoration Act in 1993 on a bipartisan basis to expand protections for religious exercise. Under RFRA, Congress addressed the court's 1990 decision by clarifying that government action may only infringe on a person's exercise of religion if there is a compelling governmental interest and if it is the least restrictive means to achieve that interest. The passage of RFRA was meant to reinstate a broader protection of free exercise rights. It was not meant to erode civil rights under the guise of religious freedom. Importantly, it did not change the First Amendment's Establishment Clause, which ensures that government cannot elevate certain religious or moral beliefs above the law. No sooner than RFRA was enacted, floodgates began to open, and RFRA has since been used to legitimize housing discrimination against single mothers and minorities, shield church groups from paying child abuse victims, and impose extreme emotional harm on school children based on their gender identity. Since the beginning of the Trump administration, this troublesome trend has only gotten worse. On May 4th, 2017, the Trump administration issued an executive order undermining RFRA's original intent and allowing individuals to use conscience-based objections to override civil rights protections. That executive order directed the Attorney General Sessions to issue guidance interpreting religious liberty protections in federal law. Instead, the Attorney General issued guidance following his own personal religious beliefs and without regard to other beliefs. The guidance has provided legal cover for the administration to permit or even promote government-sanctioned attacks on civil rights and employment, health care, foster care, and other areas under the guise of religious liberty. These attacks are spreading. For example, the Department of Education has proposed altering which institutions of higher education count as religious in the accrediting process in order to allow colleges with religious affiliation to freely discriminate. The Department of Health and Human Services misapplied RFRA to propose rolling back the Affordable Care Act's protections for patients against discrimination on the basis of race, color, national origin, sex, age, or disability. The administration has also eroded women's reproductive rights by moving to allow employers to skirt the ACA and deny coverage for contraception based on the basis of religion. The Trump administration is misapplying RFRA when it allows federal funds to be used to discriminate against families when placing foster children, and recently permitted a federally funded organization in South Carolina to restrict placement of foster children only to evangelical Christian families. This discrimination is being used to deny taxpayer-funded placements of vulnerable refugee children, in addition to the other discrimination. Finally, the Office of Federal Contract Compliance Programs, OFCCP, is allowing federal contractors to violate civil rights laws based upon the RFRA exemption only without the ability to question the sincerity or legitimacy of the claim. These examples are just a few ways the administration has twisted RFRA to threaten basic civil rights embedded in the Civil Rights Act of 1964 and other protective actions. In other words, the path of religious exemptions we're on today not only strays from President Roosevelt's original executive order signed 78 years ago, but it also threatens our civil rights and our democracy. Unfortunately, history tells us that our country will only continue this dangerous trajectory unless we act. That responsibility falls on Congress. We must pass legislation that restores RFRA's original intent. H.R. 1450, the Do No Harm Act, would help to ensure that our right to religious liberty does not threaten fundamental civil and legal rights. Specifically, the bill would prevent RFRA from being used to deny equal opportunity and protection against discrimination laws, workplace protections and protection against child abuse, healthcare access, coverage and services, and contracted services. I hope we can all agree that while religious liberty remains a fundamental value, it cannot and should not be used as a weapon to cause harm to others, but rather as a shield to protect civil rights of people of all faiths, not just a favored few. I now recognize the distinguished ranking member for the purpose of making an opening statement.
Thank you, Mr. Chairman. Thank you for yielding. The First Amendment of the United States Constitution declares that Congress may make no law, quote, respecting an establishment of religion or prohibiting the free exercise thereof. Our founding fathers reiterated this principle at every stage, that people are fundamentally free and are endowed by their Creator with certain inalienable rights. Among these, the ability to worship freely. Many of the first settlers of our country crossed the ocean in search of this very freedom that we are discussing here today. Members present in this room come from a diverse range of social, economic, and religious backgrounds. Surely this pillar of our nation's founding cannot be lost on us. The right of Americans to practice freely their religion and conduct their business without unnecessary interference from the government is as important in 2019 as it was in 1620, in 1776, and in 1789. Not too long ago, Congress reaffirmed the significance of this basic human right by passing the Religious Freedom Restoration Act of 1993. With nearly unanimous bipartisan support, RFRA stands as our nation's primary religious liberty statute, enacted to ensure that all Americans can freely express their faith without fear of discrimination. It recognizes the importance of all religious faiths, including religious minorities, and offers a safe haven for anyone seeking to practice their religion freely. By providing a sensible balancing test that allows individuals exercising their religious beliefs a fair hearing under the law. It is unacceptable that congressional Democrats, starting in earnest during the last administration, have consistently ignored how clear the First Amendment is in affirming religious practice as a fundamental human right. Actions by Democrat legislators in the name of political point scoring have eroded the rights protected by RFRA and harmed those who wish to exercise their constitutional right to freedom of religion. The Affordable Care Act and other policies of the Obama administration have imposed countless coverage mandates for contraception and abortion coverage that attempt to force individuals to violate their religious beliefs. Small business owners and religious groups have spent tens of thousands of dollars and countless hours defending their values and consciences. And the Supreme Court has ruled time and again that these attempts to limit religious expression are unlawful. We have long stood as a nation set apart from other nations because of the promises and principles of our First Amendment. Our individual liberties are the envy of people across the world, and our freedom of thought and expression are the cornerstone of this democracy. Now, more than ever, it is vital that we safeguard these fundamental rights. I stand with all House Republicans and any Democrats willing to put aside politics in the best interest of the people to defend religious freedom and the rights of religious minorities to worship freely. We will continue to oppose all policies that undermine the United States Constitution and that disrespect and diminish the faith of any American. House Republicans will also continue our steadfast support for the Religious Freedom Restoration Act and will fight any attempts to diminish or weaken the law, which has served our country well for over 25 years. Lastly, it's good to see Congressman Kennedy and Congressman Johnson join us here today. As we all know, Congressman Kennedy's legislation to limit the scope and application of RFRA is solely within the jurisdiction of the Judiciary Committee. As such, Congressman Kennedy's time in particular would likely be better spent speaking before our colleagues on that committee. Regardless, I thank both of my colleagues in advance for their testimony, and I hope we can all work together to protect the Constitution of the United States. Mr. Chairman, I'd like to make a small point of personal privilege. I have two young men from the 5th District in North Carolina shadowing me today, Reed Ballas and Lucas Snyder, and they have a particular interest in this hearing today, and I welcome them to the hearing. With that, Mr. Chairman, I yield back.
Thank you. Without objection, all other members who wish to insert written statements into the record may do so by submitting them to the committee clerk by Monday, July 8th, 2019, in the normal format. I'll now introduce our witnesses for our first panel. Congressman Mike Johnson represents Louisiana's 4th Congressional District. He's the ranking member of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties of the House Judiciary Committee. He also serves on the House Natural Resources Committee and is chair of the Republican Study Committee. Joe Kennedy, III, represents the 4th Congressional District of Massachusetts, a member of the House Energy and Commerce Committee. He has helped lead Congress on core issues of economic equity, particularly in health care and mental health. He also serves as chair of the Congressional Transgender Equality Task Force. We'll start with, let me just say that we appreciate both of you for being here today. You're fully aware of the procedures and testimony in the lighting system. And so we'll first recognize Representative Johnson.
Thank you, Chairman Scott, Ranking Member Fox, and all committee members. Appreciate the opportunity to be with you this morning. Let me begin this morning just by saying I genuinely appreciate the intellect and the sincerity and the pure intentions of my good friend Joe Kennedy. We've talked about this at some length, as well as my other good friends and Democratic colleagues who are co-sponsors and supporters of this bill. That said, I'm here today to urge opposition to this legislation because I'm convinced it would eviscerate one of the most important and widely regarded laws that's ever been passed by the Congress, and that's the Religious Freedom Restoration Act, or RFRA as we call it. I did want to just make a quick remark. I do find it a bit curious that we're here instead of over in our subcommittee on judiciary. I'm looking at my chairman up there, Mr. Cohen. We would have a good time with this, but it's here for whatever reason, so I found out about it yesterday and I came to be a part of it. I bring you today firsthand knowledge and experience of the benefits and importance of the Religious Freedom Restoration Act because prior to my election to Congress, I served for nearly 20 years as a constitutional law attorney and religious liberty defense litigator. For more than 25 years now, RFRA has helped secure the fundamental right of Americans to live and work according to their sincerely held religious beliefs. We can never lose sight of the importance of this protection. For so many reasons, we know religious liberty is often referred to as our first freedom. The founders listed it first in the Bill of Rights because they understood the right to believe and to act upon that belief is essential to who we are as Americans, but more fundamentally than that, who we are as human beings. When that premise was placed in some doubt by a decision of the Supreme Court in 1990's Employment Division v. Smith, Congress responded with a truly bipartisan effort that was led by giants on both sides of the aisle. Ironically, Senators Ted Kennedy and Orrin Hatch, and then Representative Chuck Schumer. The 1993 Religious Freedom Restoration Act received overwhelming support also from more than 60 national religious and civil liberties organizations from across the philosophical and political spectrum. The bill passed unanimously in our House and received only 3 dissenting votes in the Senate. It was celebrated and signed by President Bill Clinton, who held it as, quote, who held the, quote, broad coalition of Americans who came together to make this bill a reality, unquote. The reason all those diverse groups came together was because the Smith decision had caused great alarm around the country. In that case, the Supreme Court ruled against 2 Native Americans who were terminated from their jobs because they failed a drug test after using peyote in a traditional religious ceremony. As you might expect, many of the conservative and religious groups, and even many members of Congress who voted for RFRA, didn't personally agree with the religious practices of the peyote users. In fact, the House Judiciary Committee itself specifically disclaimed support for any particular practices that RFRA might be used to uphold. But the personal views of the lawmakers was not the point. Everyone, both liberal and conservative, recognized that even the sincerely held religious beliefs of small minority groups are important for us to protect. RFRA supporters understood that one day it could be their own religious beliefs and practices that would be unpopular and face government scorn and restriction. So RFRA was created to provide a very reasonable balancing test, and this is the key. It's a balancing test in our civil rights law. It preserves and seeks to preserve both religious liberty and the rule of law. As Senator Ted Kennedy said, the lead Senate sponsor, he explained at that time, quote, "The act creates no new rights for any religious practice or any potential litigant," unquote. RFRA merely protects the right of every American, regardless of their political belief system or their religious belief system, to have a fair court review anytime the government takes an action that forces them to violate their deeply held religious beliefs. Simply put, as it's been stated already, the balancing test provides that the government cannot substantially burden the exercise of religious belief unless the government can prove that the burden serves a compelling government interest that is accomplished by the least restrictive means. It's important to emphasize again that all RFRA provides is a fair hearing. It doesn't determine any outcome. In fact, as Attorney Matthew Sharp has pointed out in his written statement for the committee today, in the quarter century since RFRA was enacted, people who have sought protection for their religious practices under the statute have only been successful in 16.3% of appellate court opinions and 17.6% of district court opinions. In other words, the government almost always wins. The Do No Harm Act that you're hearing today was originally drafted and filed in the immediate wake of the Burwell v. Hobby Lobby decision in 2014. As you know, in that case, the Supreme Court recognized a very narrow exception and held that the contraceptive mandate provision in the Obamacare statute could not be used to force the owners of a specific closely held business to violate their sincerely held religious convictions. Critics of the Hobby Lobby decision insisted that the decision would, quote, open the floodgates to all sorts of new claims under RFRA and to, quote, impose Christian values on America and use religious freedom as a new license to discriminate, unquote. That simply has not happened. In fact, as the Beckett Religious Liberty Defense Organization has pointed out, quote, a recent comprehensive empirical study of religious freedom cases post-Hobby Lobby reveals that religious minorities remain significantly overrepresented in religious freedom cases, and Christians remain significantly underrepresented, unquote. Scholars in a 2018 Law Review article documented that, quote, lawsuits filed post-Hobby Lobby similarly found that Hobby Lobby has not had a dramatic effect on government win rates and religious exemption challenges, nor have religious claims undergone a dramatic expansion in volume following the case. If anything, the volume of these cases appears to be slightly decreasing as a percentage of overall reported cases, unquote. It is worthy of note, too, that Beckett highlights the fact that several of the 21 states that have adopted and maintained state-level RFRA statutes since the 1990s, like Connecticut and Illinois, for example, are listed among the most favorable states for LGBT protections. As I told my friend Joe Kennedy on the House floor last night, I know he and my other good friends who are co-sponsors of this bill are very sincere and well-intended. But so are the countless supporters of the RFRA statute and the religious minorities who rely upon it to preserve their most basic and inalienable rights and their right to provide essential goods and services to their communities. In a government of, by, and for the people, our constant challenge is to maintain a balance of the competing interests in society. The balance test of RFRA that was originally championed and enacted by the leaders of the Democratic Party has served our nation well. The legislation proposed today would eviscerate that tried, true, and cherished legal protection and effectively repeal it. Ironically, the Do No Harm bill would cause great harm and immediate risk to the religious people and the thousands of religious organizations of all faiths in this country who provide the essential food, clothing, shelter, counseling, and social services, jobs, and well-being for millions upon millions of Americans. I urge my colleagues to proceed here with great caution, and let us work together, as they have in previous Congresses, to uphold and maintain the critically important RFRA statute in its current form. It works, and it should not be changed. I thank you, Mr. Chairman. I yield back.
Thank you. And I note you mentioned the question of jurisdiction. This committee has jurisdiction over matters related to equal employment opportunities, like the EEOC. Has jurisdiction over many health and human services programs, particularly those in child adoption. And the South Carolina case that I mentioned specifically used RFRA to deny opportunities. So all of those social services programs and the discrimination in those programs are within the jurisdiction of this committee. Representative Kennedy.
I want to thank the chairman for holding this important hearing and for his decades of leadership on this issue and so many issues with regards to our civil rights. I want to thank the ranking member as well for her comments, my colleagues on both sides of the aisle for attending today's important hearing, and my good friend, Congressman Johnson, for his dedication to these issues, for his engagement last night and over the course of the past several weeks, and a commitment to try to work together to discuss some of these issues as well. In 1993, Congress passed the Religious Freedom Restoration Act with overwhelming bipartisan support in response to Unemployment Division v. Smith, which saw 2 Native Americans fired from their jobs and denied unemployment after they consumed a controlled substance outside of work as part of their religious faith. For these Native Americans and other religious minorities like them, RFRA was meant to be a shield that protects, because Native Americans should be free to practice a religion, because Jewish children should be able to wear yarmulkes in public schools that prohibit them, because restrictions on facial hair should contain exceptions for those of the Muslim faith, However, over the years, RFRA has morphed from a shield of protection to a sword of infringement, allowing employers to undermine basic workplace protections, organizations to stonewall child labor investigations, and health providers to deny needed care for victims of sexual abuse. The Supreme Court's 2014 ruling in Burwell v. Hobby Lobby opened the door for these floodgates even further, providing a path for corporations to cite their faith in discriminating against their employees. Since then, we have witnessed an administration that has laid the foundation for discrimination in the name of religious liberty at every conceivable opportunity. Right now, the Trump administration is fighting to make it easier for women to be denied critical contraceptive coverage on the basis of an employer's religious and moral beliefs. The Department of Justice issued a memorandum to all federal agencies and departments, permitting employers to use their religious beliefs to discriminate in employment, even with publicly funded dollars. Earlier this year, the administration granted a request from South Carolina to use RFRA to waive non-discrimination requirements for state-contracted child welfare agencies. That ruling allowed Miracle Hill Ministries, the state's largest foster care provider, to turn one woman, Amy Madonna, away because she is Catholic and not Protestant. Only a few weeks ago, the administration cited RFRA to roll back the ACA's coverage that to allow discrimination in healthcare, simply because a person in need of healthcare happens to be transgender, or because of a woman's reproductive healthcare decisions. It is precisely for these reasons that Congressman Bobby Scott and I introduced the Do No Harm Act, to restore RFRA to its original purpose as a protective shield for religious minorities, and to clarify that no claim of religious exemption from laws that protected discrimination, that govern wages and collective bargaining, prohibit child labor and abuse, provide access to health care, regulate public accommodations, provide social services through government contracts. The Do No Harm Act confirms what generations of civic history, constitutional law, and American experience have proved true. If civil liberties and legal rights exist only in the absence of a neighbor's religious objection, then they are not rights, but empty promises. The ability to freely and fully exercise sincerely held religious beliefs in this country is a liberty we all cherish. It's a bedrock foundation of this country. Across the nation, religious principle inspires countless families, organizations, and communities to champion economic justice, human dignity, common decency, and freedom. But there is a difference between exercising religious beliefs and imposing them on others. Our Constitution fiercely protects the former and expressly prohibits the latter. With civil liberties under attack, now is the time to affirm that with religious beliefs of one person do not supersede the civil rights of another, and that there's no religious exceptions to equal protection. It's time to restore RFRA to what it was originally intended to be. Thank you, Chairman. I yield back.
Thank you, and I want to thank Congressman Johnson and Congressman Kennedy for taking time to testify before the committee today. Your testimony is a valuable piece of the legislative record, and I want to thank you both for being here. We'll now seat the second panel. We'll delay for a minute or two as they get situated. We ask our witnesses to come forward. I'll now introduce our witnesses for the second panel. Rachel Lazar is the President and CEO of Americans United for Separation of Church and State, She formerly served as the Deputy Director for the Religious Action Center for Reformed Judaism, Director of the Culture Program at Third Way, and Senior Counsel at the National Women's Law Center. Shirley Wilcher is the Executive Director of the American Association for Access, Equity, and Diversity. She previously served as Deputy Assistant Secretary for the Office of Federal Contract Compliance Programs during the Clinton administration. Notably, she worked for this committee as Associate Counsel for Civil Rights under Chairman Augustus Hawkins. J. Matthew Sharp is Senior Counsel for the Alliance Defending Freedom, where he directs the Center for Legislative Advocacy. He previously served as an associate at Equitas Law Alliance, PLLC. Reverend Jimmy Hawkins serves as the Director of the Presbyterian Church USA Office of Public Witness in Washington, D.C. For 20 years, he served as a pastor of Covenant Presbyterian Church in Durham, North Carolina. He also serves as a board trustee with Union Presbyterian Seminary and has chaired several interfaith, ecumenical, and nonprofit boards. We appreciate all of the witnesses for being here today and look forward to your testimony. Let me remind the witnesses that your written statements will appear in the hearing record, and will appear in full in the hearing record. Pursuant to Committee Rule 7D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. Let me remind you that it is unlawful to willfully falsify statements to Congress, and so since you know that, we won't swear you in. Before your testimony, please remember to press the button on the microphone in front of you so that it'll turn on and members can hear you. As you begin to speak, the light will turn green. 4 minutes. After 4 minutes, the light will turn yellow to signal that you have 1 minute remaining. When the light turns red, it indicates your time has expired, and we'd ask you to wrap up as quickly as possible. We'll let the entire panel make presentations before we move to member questions. When answering a question, please remember to once again turn your mic on. Ms. Lazar.
Good morning, Chairman Scott, Ranking Member Fox, and committee members. Thank you for the opportunity to testify on this critical issue. Last winter, I met Amy Madonna. Amy, her husband, and 3 kids want to open their home to children in foster care. Amy was thrilled when, after going through an intensive screening process, Miracle Hill Ministries said her family was just what they were looking for. But then they had one more question. What church do you attend? They asked because Miracle Hill only accepts evangelical Protestants. Amy couldn't pass that test because she's Catholic. Neither could Beth Lesser, who was turned away because she's Jewish, nor could Eden Rogers and Brandy Welsh, a same-sex Unitarian couple, also rejected. Despite accepting $600,000 in federal and state taxpayer money, Miracle Hill imposes a religious litmus test on potential parents and volunteers. This discriminatory policy denies children in the foster care system the love and families they need. Miracle Hill says religious freedom allows them to engage in this blatant religious discrimination. The Trump administration agrees and has used RFRA to exempt Miracle Hill from complying with a federal anti-discrimination law. But this isn't what RFRA was intended to do. RFRA was enacted in 1993 in response to the Supreme Court's Employment Division v. Smith opinion. Faith groups, legal experts, and civil liberties groups, including Americans United, came together across political divides to preserve religious freedom protections, especially for religious minorities. Allowing RFRA to be used to harm others also violates the Establishment Clause of the First Amendment. The government can't make you pay the cost of my religious exercise because that's preferring my faith to yours. Unfortunately, the Trump administration is ignoring the intent and constitutional limitations on RFRA. It's weaponizing RFRA to undermine civil rights protections, deny people access to health care and government services, and even deny children loving homes. This harms LGBTQ people, women, the non-religious, and religious minorities the most. RFRA, a statute designed as a shield to protect, is now being used as a sword to harm others. The Trump administration has cited RFRA to create harmful religious exemptions, and more are coming. In addition to the South Carolina foster care waiver, employers are now allowed to deny their employees insurance coverage for birth control promised them by the ACA, and a Labor Department directive expands the ability of federal contractors to cite religion to discriminate in hiring. Efforts to use religion to undermine civil rights protections are nothing new. In 1968, the Supreme Court rejected arguments that a restaurant owner could refuse to serve Black patrons because it was, quote, the will of God. Federal appeals courts as recently as the 1990s rejected Christian schools' claims that religious freedom allowed them to give married men larger benefits and salaries than women. Today, we must continue to reject efforts to use religion to justify discrimination, and Congress can help. First, it should conduct oversight hearings on the administration's misuse of RFRA. And second, Congress should pass the Do No Harm Act, a simple yet critical bill designed to restore RFRA to its original intent. It will preserve the law's power to protect religious freedom while clarifying it may not be used to harm others. Under the Do No Harm Act, RFRA would still provide protections, like ensuring sick service members can wear articles of faith while in uniform. RFRA couldn't be used, however, to allow a government-funded homeless shelter to turn away a transgender person, or to allow a homeowners association to exclude non-Christians. Our country is strongest when we are all free to believe or not as we see fit, and to practice our faith without harming others. Like Amy Madonna said, if you don't protect the rights of everybody, it sets a precedent that will eventually touch on you.
Thank you. Ms. Wiltshire.
Good morning, Mr. Chairman and members of the Committee on Education and Labor. My name is Shirley Wiltshire, and on behalf of my association, the American Association for Access, Equity, and Diversity, I appreciate the invitation to testify about the potential application of the Religious Freedom Restoration Act in the employment context. We have been asked to opine on the particular implications of RFRA on the enforcement activities of the U.S. Department of Labor's OFCCP, the Office of Federal Contract Compliance Programs. Founded in 1974, my association has 4 decades of leadership in providing professional training to members, enabling them to be more successful and productive in their careers. It also promotes understanding and advocacy of affirmative action and other equal opportunity and related compliance laws to enhance the tenets of access, inclusion, and equality in employment, economic, and educational opportunities. We at AAAED, we call it, remain committed to preserving the laws enacted in the 1960s and beyond that were established to promote equal opportunity for those who have been historically disadvantaged based on race, religion, sex, national origin, disability, and more recently, sexual orientation and gender identity. We endorse the recently House-passed Equality Act and urge its passage in the Senate. We also support the Do No Harm Act and this committee's work to continue the legacy of Augustus Hawkins and other legendary members of this committee who labored to secure employment opportunities for increasingly diverse American workplace. The Office of Federal Contract Compliance Programs, as you know, enforces 3 laws, including Executive Order 11246, that prohibit discrimination. The underlying philosophy of these civil rights era laws is that federal funds should not be used to support discrimination. They should be used to promote equal employment opportunity. Last year, the federal government issued and entered into $560 billion in federal contracts. That is a lot of funding, and it is important that that money not be used to promote equal employment opportunity. You know the tenets of RFRA, that it prohibits any agency, department, or official of the United States or any state government from substantially burdening a person's exercise of religion, even if the burden results from a rule of general applicability, except that the government may burden a person's exercise of religion only if it demonstrates that application of the burden to the person furthers a compelling government interest and is the least restrictive means of furthering the governmental interest. On August the 12th, the OFCCP issued a directive on the Religious Freedom Act, and it included a directive that the directive was to incorporate recent developments in the law regarding religion exercising organizations and officials. The directive also iterated the purpose of the administration's executive orders to protect religious exercise, not impede it. The OFCCP staff are ordered to take these legal developments into account in their compliance activities. They must respect the right of religious peoples and institutions to practice their faith without fear of discrimination or retaliation by the federal government. We have reviewed the available compliance activity of the OFCCP and found few cases involving religion. According to the agency statistics, only one case between 2015 and 2018 in which a violation of religious day observance was identified. However, in the preamble to the final rule to the sex discrimination regulations handed down in 2016, the OFCCP addressed the issue of RFRA, and it said it declined to implement a blanket exemption from these provisions. However, and there is no formal process for invoking RFRA specifically as a basis for exemption under EO 11246. However, insofar as the application of any requirement under this part would violate RFRA, such application will not be required. Let me emphasize that the executive order already requires an exemption for religious organizations, and it tracks the exemptions from the the Equal Employment Opportunity Commission. But our concern is about the effects of the application of RFRA. We're particularly concerned about the impact on the LGBT community, but not others. In some respects, what we saw in the South Carolina case and HHS is worrying us because it really is reminiscent of the lunch counter issues. How far do we go in the implication and the impact of that particular provision? We are also concerned because the OFCCP, when I was at the Department of Labor, let me say, there was discrimination that I found shocking. Between 1994 and 2001, I put together what we called egregious cases to remind America that discrimination is alive and well, and that includes cases involving the Ku Klux Klan. I can elaborate later, but all of that is to say RFRA adds insult to injury in our view because discrimination is alive and well, and there are exceptions for religious organizations.
Thank you. Mr. Sharp.
Good morning, Chairman Scott, Ranking Member Fox, and members of the committee. I'm Matt Sharp, Senior Counsel with Alliance Defending Freedom. One of our nation's greatest hallmarks is its commitment to protecting fundamental human rights, rights rooted in human dignity. Among these inalienable rights is religious freedom. A person's religious beliefs are core to their identity and even to their relationship with those around them. These deeply held convictions guide them and even compel their commitment to social justice and to the community. From an evangelical-run homeless shelters or an Islamic hunger relief program to a Catholic-run adoption and foster care provider, these charitable organizations should not be forced to choose between abandoning their beliefs that inspire their service or being denied fair and equal treatment by the government. Such action would not only undermine these national virtues that make us unique, but it would also have a devastating impact on some of the most disadvantaged members of society. Children displaced by the opioid crisis in need of a loving home, survivors of sex trafficking and domestic abuse seeking shelter, the addicted longing for relief, and low-income families in dire need of a roof over their heads. Every day, people of faith serve their neighbors, offering food, clothing, shelter, and other social services. They provide jobs for thousands. And while this economic benefit of religion was recently valued at $1.2 trillion annually, we can't put a price on the countless lives forever changed by a helping hand from faith communities. But religion's vast benefits to the whole of American society will only last so long as people of faith maintain the freedom to exercise religion, not just in their home or place of worship, but at work and in the wider community. Unfortunately, proposals like the Do No Harm Act undermine that liberty. The Act's sole purpose is to declare open season for government regulation on broad swaths of religious exercise by individuals, houses of worship, nonprofits, and many more, without offering any meaningful judicial scrutiny whatsoever. The Act would impose great harm on religious minorities by conditioning their free exercise on the whims of those in power who seek to disfranchise disfavored views. But RFRA safeguards every person's ability to peacefully live, work, and act consistent with their beliefs. even when those beliefs might be politically unpopular. RFRA gives those burdened by the weight of intrusive government regulations a judicial forum where their voice can be heard and relief can be sought. For many people of faith, from Native Americans and Muslims to Rainbow Family and Rastafarians, every aspect of their lives has eternal consequences. The Muslim prisoner believes it's disrespectful to the Prophet Muhammad to shave his beard. The Jewish shop forced to open on Sundays would openly defy the Torah's command to remember it as a day of rest. The Catholic nun mandated to pay for abortion-inducing drugs would trample underfoot the sanctity of an innocent human life. And the grandmother florist, told she must design a floral arrangement for a friend's same-sex wedding, would dishonor a sacred institution established by God. We may not share these beliefs, but the real test of religious liberty is what happens when we disagree. Disagreement is not discrimination, and it should never be treated as such. Nor should disagreement provide justification to shut the doors of the justice system to minority beliefs simply because the winds of societal acceptance have shifted direction. Few of us here today would support the religious practices of the Peyote drug users in Employment Division v. Smith or any of the other cases involving controlled substances and religious rituals. But I think we can all recognize that one day the winds may change, and it could be our religious practices facing government scorn. RFRA was crafted to take the thumb off the scales of justice that had been used to favor government over people of faith. It restored that proper balance, one that honors the high place that religious freedom and exercise holds in our constitutional system. It doesn't determine winners or losers, nor does it mean that religion will prevail. RFRA simply protects the process for balancing the government's interest with individual freedom. And that process helps to safeguard values that all of us here today hold dear. Values like diversity, like human dignity, freedom for all, and the conviction that no American should suffer discrimination at the hands of the federal government for publicly living out their faith. 25 years after RFRA, our nation is more diverse than ever. We hold increasingly divergent views on beliefs ranging from marriage and abortion to immigration and the opioid crisis. And people of faith continue to find themselves caught in the crossfire, as their beliefs and practices are both misunderstood and subject to popular scorn. In these times, the need for RFRA has not diminished. Today, RFRA is more vital than ever. Thank you.
Thank you. Reverend Hawkins.
Good morning, Chairman Scott, Ranking Member Fox, and committee members. Thank you for this opportunity to be with you here today. I am an ordained minister with the Presbyterian Church USA and serve as the director of the church's Office of Public Witness. Religious freedom is sacred to me and to my denomination. For more than 200 years, our historic principles have recognized the importance of religious freedom. And of course, it is a fundamental American value. In 1993, consistent with our teachings, the Presbyterian Church supported the passage of RFRA as a way to allow persons and religious groups to practice their faith without constraint of the government. Unfortunately, over the years, RFRA has become a weapon aimed at excluding, marginalizing, and discriminating against vulnerable populations. This misinterpretation of RFRA runs counter to religious freedom and the teachings of my faith. In our commitment to be disciples of Jesus Christ, my church is called to stand against oppression and in support of human dignity for all people, because religious freedom must be equal and common to all. It cannot be maintained as a matter of privileged exemption for powerful individuals or groups. Religious freedom gives each of us the right to believe in accord with our own conscience and practice our faith, as long as we don't hurt others. We believe it weakens religious freedom when it is invoked in ways that deprive people of their civil and human rights to equal protection under the law or seek to justify exclusion and discrimination. Presbyterians have historically valued religious liberty and continue to support the freedom to act according to one's religious beliefs. However, in cases involving the refusal of goods and services, false claims of religious freedom cause direct harm to those who are denied access. Legislating such claims as cases of protected religious freedom would undermine years of progress in state and federal civil rights and anti-discrimination law. As Chairman Scott gave comment to the battles over slavery and racial segregation, religion and scripture are often cited as justification for maintaining inequality. People even heard it preached from pulpits on Sunday morning. Until the Civil Rights era, refusals to serve African Americans were often cloaked under the guise of religious freedom, as well as support for slavery, which was given a theological and biblical undergirding. In the end, we're called here today to stand for the religious freedom and the rights of the individual. United States civil courts have rightly rejected the claims of those who have said that racial integration would violate their religion. Invoking religious freedom to deprive people of their rights is still occurring today, as we see RFRA is being misused to cause harm. Over the years, individuals and businesses have found ways to circumvent the original purpose of RFRA, to discriminate against persons and to impose their religious beliefs on those who believe otherwise or who don't even believe at all. Personal prejudices have been enforced under the guise of religious sentiment. In this way, some dominant religious groups have not been able to persuade us to stop the march to greater equality, are now claiming discrimination, trying to use religious freedom as their last refuge. In 2018, motivated by this misuse of RFRA and other religious freedom laws and policies, the Presbyterian Church passed a resolution to stand against any invocation of religious freedom in the public sphere that deprives people of their civil and human rights to equal protection under the law, or that uses religious freedom to justify exclusion and discrimination. That is why today, the church supports the Do No Harm Act, which will return RFRA to its original intent. It will protect religious freedom, but not be used to harm others. There can be no religious freedom without equal respect for the dignity of all persons, a dignity that is denied when services are refused. When claims of religious freedom become public efforts to exclude and discriminate, we're called to speak up for justice and to stand with the oppressed. Thank you.
Thank you. Under Committee Rule 8A, we'll now question witnesses under the 5-minute rule. And we'll first recognize the gentleman from Connecticut, Mr. Courtney.
Thank you, Mr. Scott, for holding this hearing today, and thank you to all the witnesses for your testimony this morning. Listening to, again, what we've heard here today, it does seem like you have to go back a little bit to 1994 when the RFRA law was passed. And again, Ms. Laser, you sort of alluded to the fact that, again, this was an attempt to rebalance the law after the Smith decision, which, can you talk about what the law looked like prior to that Smith decision in terms of the balancing test between compelling state interest as well as restrictions being protected?
Yeah, sure.
Can your microphone, please?
Hi. Prior to the Smith decision, the law was much like the RFRA balancing test intends to be. So if you had a sincerely held religious belief that was substantially burdened, the only way that that could be overcome is if the government had a compelling interest and it was narrowly tailored. And that law was sort of working until Employment Division v. Smith, when Scalia wrote his opinion. RFRA was in response to that previous balancing being out of whack from Employment Division v. Smith, and that's why so many groups across political divides came together. Everyone agreed that these Native Americans engaging in this healing peyote smoking ceremony deserved protection from these prohibitions on receiving unemployment if you failed a drug test. So that's why it came into being. Unfortunately, soon after RFRA passed in 1993, there started being indications that it was going to be misused in the ways that we're seeing so much of today. For example, commercial landlords right away argued that RFRA gave them the right to impose their religious beliefs that people shouldn't be cohabitating before marriage and to ignore housing discrimination laws and refuse housing to unmarried couples. So we did start to see that pretty soon after RFRA passed, but what's really important is RFRA would have never passed as a consensus bipartisan bill had it been assumed that it was going to cover cases like that.
So basically what's happened is that the compelling state interest has sort of been continued to be degraded to the point where it really, again, as has been testified, became more of a sword rather than a shield in terms of protected groups.
Yeah, and in the Hobby Lobby case in particular, the court actually changed the meaning of substantial burden and sort of made it much easier to meet, much more like just meeting the sincerely held religious belief test. And they also made it harder for the government to prove that they had a narrowly tailored solution to their compelling interest. And so the court actually changed the balancing test for the worse from pre-Smith law in the Hobby Lobby decision.
So you described one example in your testimony of a homeless shelter refusing access to a transgender person. Again, the compelling state interest in that case is where federal funds are paying to support the emergency housing. Emergency housing is the compelling state interest, which should be upheld despite whatever a person's view is of a transgender or other minority individual.
Exactly. Government services are provided for people in need. We feed people, we give people shelter, we take care of people when they're in dire conditions, like Samantha Coyle in Alaska, who is a transgender woman who showed up at a government-funded homeless shelter and was turned away and had to sleep in the woods. And that's not how we want our government acting, denying much-needed services to people in the name of religion.
And other examples of compelling state interest would be, again, access to health care coverage for medically prescribed services, which, again, if you degrade the compelling state interest, it effectively becomes a barrier for people getting what their doctors tell them they need. Is that correct?
Absolutely. We need to put patients first, and that's not happening with a lot of the regulations that we're seeing today come out of the Trump administration in the name of RFRA and religious freedom.
So the Do No Harm Act, I mean, is that sort of the purpose is for Congress, again, to revisit this issue and to restore what was the original intent of RFRA, and again, what was traditionally the way the Supreme Court interpreted the free exercise clause. Is that correct?
That's right, and also to make sure that we're holding to the Constitution and the Establishment Clause. So RFRA doesn't change the the Do No Harm Act doesn't change the balancing test that we're talking about. It just makes sure that the Establishment Clause law is in effect. And the Establishment Clause says that you can't use your religion to cause harm to third parties. There's a line of Supreme Court cases that say that, Calder and Cutter, and it's been very clear. It was clear from our founding framers as well, and that's what the Do No Harm Act does.
Great, thank you.
Thank you.
Thank you. The gentleman from Tennessee, Dr. Rowe.
Thank you, Mr. Chairman. We have a First Amendment right to practice our religion in America, and the government forcing someone to act in a way that violates those beliefs is in direct opposition to the very foundation of our Constitution. The Religious Freedom Restoration Act protects our First Amendment right. The RFRA does not predetermine winners and losers, and in fact, as noted in testimony, over 80% of the time, the court rules in favor of the government, not under RFRA. My colleagues on the other side of the aisle will tell you that RFRA is being used as a license to discriminate. That is not true. The RFRA protects people of faith from discrimination by allowing them to challenge government actions that would burden their freedom to practice their religion. This is not about forcing religious beliefs on anyone. This is about not forcing people of faith to abandon their beliefs. Now, I want a question for either Mr. Sharp or Reverend Hawkins. In 2016, the Obama administration, HHS, published final rules under Section 1557 of the Affordable Care Act that expanded the definition of sex to include gender identity and termination of pregnancy. Under these rules, would religious hospitals or doctors be forced to offer or perform procedures that violated their beliefs or values? And what are the consequences for providers that choose not to violate those beliefs? I am one of those providers. As a matter of fact, I look at the diocese, I'm the only one up here. I'm an OBGYN doctor. So what is the answer to that question?
Thank you for the question. And when you look at what was originally enacted with 1557, it was protecting against sex discrimination. And then that was ultimately through an HHS regulation expanded to include gender identity. But you bring up the importance of the purpose of RFRA and that balance it provides, because for a medical provider, they may have deeply held religious beliefs regarding a variety of medical services, and what we want to make sure is that provider has a process by which they can go to court and explain their religious convictions, and then at the same time, the other side, the government, can go to court and explain their interest involved as well. What we want to secure is that process for physicians like yourself, for medical providers across the country, just to have that access to the doors of justice to plead their case in court.
I think it is indeed a delicate balance, and it is difficult to have the identity of a doctor and of a Christian. But I do like the name of the act, Do No Harm. And I've said past that doctors have stolen our Christian theme because we are called to do no harm in our faith. I think there are always limitations on either side. And I think that as a minister, there are limitations that have to be imposed upon me and my serving.
The question I have is not that. The question I have is, will I be forced to perform something that I believe is wrong, which is an abortion?
The question is, will you be forced? You mean by government regulations?
That's correct. Just what I'm asking, if this happens, would providers like myself be forced to do a procedure they believe is morally wrong?
I think there will be times that you're going to have to struggle with that question.
I don't have any struggle with it at all. I have none.
I think that in our Christian walk, there are times when we are, if you want to use the word force, we're compelled to do things that might personally bother us. For example, as I was about to say, as a minister, I counsel others. And yet if I learn, and there's a
This is not what I'm not talking about counseling somebody. I'm talking about actually doing a medical procedure. That's what I'm asking. Well, in testimony, Mr. Sharp, it has been mentioned that without RFRA protections, many religious organizations will be forced to stop providing services such as homeless shelters, community gardens, nursing home services, and more to the general public. When it comes to preventing services mandates, do you believe that the impact would include providing health coverage for employees? Do you believe that organizations will be forced to drop coverage altogether rather than violate their beliefs?
Thank you. And I think that is among the concerns that RFRA is designed to help prevent. When you look at the claims brought by a variety of groups, whether it was Little Sisters of the Poor, Geneva College, the Mennonite Conestoga Wood Specialties, and others, they were facing this very difficult choice of, we want to take good care of our employees, but we also have that duty to God that we're trying to honor. And we want to balance that. And the best way we do it is, let's provide great health care, but at the same time, don't force us to pay for things and to support things that we believe violate that sanctity.
I want to say one other thing. My time's about expired, but the Hyde Amendment states it's so that we don't intend to use federal dollars to fund abortion. I think in a private business asking for the same protections with private dollars as with public dollars when they have to provide a service they don't think they should. Mr. Chairman, I yield back. Thank you.
Thank you. Gentleman from Northern Mariana Islands, Mr. Sablon.
Yeah, thank you very much, Mr. Chairman, for holding today's hearing. I find some quiet time every day in my life to just contemplate on if there's something that I had done or something I had failed to do to harm someone or make someone even uncomfortable, and that how I could fix that. I try to live my life that way. I don't always succeed, but I know I'm not condemned to hell because I do that. But let's talk about recent law. When Congress passed the Affordable Care Act, our country took a historic step forward on the path towards health care justice by protecting millions more from discrimination in health care settings. Specifically, Section 1557 of ACA prohibits federal health programs and entities that receive federal financial assistance from discriminating based on the race, color, national origin, sex, age, and disability status. I was hoping that the panel might be able to briefly discuss the importance of these protections for the American people. So, Ms. Laser, may I ask, prior to the ACA, what protections existed to prevent discrimination in healthcare, and how did they compare to the protections in Section 1557?
Thank you. The Healthcare Rights Law 1557 is a landmark piece of legislation, in large part because, remarkably to me, actually as a woman, it's the very first law to prohibit discrimination on the basis of sex by healthcare providers that receive federal financial assistance. First time ever. in healthcare law. So that applies to healthcare programs that receive financial assistance from the government. Right. And what that means, according to settled case law, is that it prohibits not just discrimination against women, but discrimination based on gender identity and also sex stereotyping, because that's what the courts have found sex discrimination includes. It also includes discrimination on the basis of pregnancy and pregnancy-related conditions, including termination of pregnancy. And the other aspect of this bill that's wonderful is it recognizes that there's discrimination in access to health care if you're not acknowledging the difficulties to access for people who are limited in their English proficiency. And therefore, it brings along provisions that takes care to give translation, notices, taglines, and such for people who aren't native English speakers.
Yeah, like for myself, I have a limited number of English words every day, so once I use it up, I get confused. You know, there really is a reason why there's a saying that, you know, we don't discuss politics and religion at the kitchen table when we sit down for a meal. Otherwise, it could go on. But Ms. Laser, what impact would ending these protections that we just talked about have on communities historically subject to discrimination in healthcare, as well as the remote island communities like the colonies, like my district, with access to challenges and ongoing provider shortages?
Yeah. You know, sometimes when you belong to a majority group, it's hard to even understand or know the difficulties and challenges that people face who are part of minority groups. But there are extensive difficulties that folks who are part of minority groups face in the healthcare system and barriers to access. People who are transgender, reportedly 1 in 4 don't even go and seek care because they're so concerned about being harassed or turned away by the healthcare system. Okay. Women have confronted many problems. Many studies don't even reflect how drugs affect women's health. Women haven't been taken into account, and women would suffer, and so would gays and lesbians who, you know, lesbians are turned away from physicians, et cetera.
Laser, reclaim my time. I have one question. Reverend, you said this in your statement. Today we see RFRA being misused to cause harm. Can you, in that very short time, express that?
Yeah, many of the cases that we have examined wherein a transgender woman was fired because she was transgender, wherein individuals find themselves, such as seeking to be foster parents, and because of their religious beliefs do not align with the agency that's in charge, they're denied the opportunity to be foster parents.
Yeah, but my time is up, so, but I think God spoke to someone and said, remove that person from this service because his different religion. There's only one God.
Yes, and God loves us all.
I love you too, Reverend. Thank you.
Thank you. Gentleman's time has expired. Mr. Thompson.
Thank you, Chairman. Thanks, members, all the members of the panel for being here. Mr. Sharp, you know, I appreciate you being here today. A notable feature of RFRA is that it requires the government to explain and justify a restriction on religious liberty. I mean, our country was formed by those who were seeking religious liberty. The government must show that there's a compelling interest, and the restriction is the least restrictive means of achieving the interest. Now, does RFRA give individuals some much-needed leverage when dealing with the federal government, and does it increase government transparency and accountability?
Yes. RFRA is a check on oppressive government regulation. It gives that religious minority whose practices are burdened by a government rule or regulation a check that they can go to court, and they can let their voice be heard and have an opportunity to seek relief from what the regulation imposes on them. So absolutely, it creates government accountability, and it requires the government not only to respond when it infringes, but even when they're looking to pass laws, looking to enact regulations, to take a step back and say, is this going to impact the religious exercise of an individual? And make sure that they're showing that proper protection and that proper respect for our First Amendment rights.
I'd like to follow up about RFRA as it relates to the Affordable Care Act. As you know, the Trump administration released 2 interim final rules in October 2017 dealing with moral exceptions and religious exemptions for coverage of certain preventative services under the ACA. With that being said, can any employer decide that they no longer wish to pay for preventive services and claim a religious or moral exception under these recently finalized rules? And are there guidelines in place for employers looking to use these exception processes?
Thank you for that question. So after the Affordable Care Act and the contraceptive mandate, we saw numerous organizations, nonprofits, the Little Sisters of the Poor, Geneva College, and a few closely held businesses as well, find their beliefs at conflict in the law. I thought it was interesting. I was reading something recently, I think it was former ACLU President Nadine Strauss, and that when even RFRA was being debated in 1993 and 94, specifically raised this concern that absent RFRA and under the Smith ruling, religious organizations could be forced to provide abortions or contraceptives. And so what this ruling and Little Sisters of the Poor and others and this recent interim rules do is show that proper respect for people of faith, to give those that have a deeply held religious belief or moral conviction about the sanctity of life the opportunity to get an exemption, not from providing health care, but from providing a handful of contraceptives or other items that they believe terminate innocent human life. And so what these do is protect that freedom of conscience, again, a very tailored, balanced approach that protects those while also furthering the other interests involved in healthcare.
Thank you, Mr. Sharp. Chairman, I yield back the balance of my time. Or I yield to the ranking member.
I thank the gentleman for yielding. Mr. Sharp, your testimony cites several studies on Religious Freedom Restoration Act cases. One study said 70% of RFRA claims are made by individuals, 15% by houses of worship, and 15% by nonprofit organizations, educational institutions, and for-profit businesses. There were only 3 reported cases brought by for-profit companies. What does this data say to you about who is being protected by RFRA?
I think it demonstrates that RFRA is continuing to serve those who are most impacted by oppressive government regulations. It's often the individual, the place of worship, the nonprofit, very powerless organizations that most feel the brunt of any government regulation. And so, again, the study you're referencing was done in 2018, so this is post-Hobby Lobby looked at it and said, what we're continuing to see is a pattern that these individuals and houses of worship are making up the majority of cases, the majority of instances where a person of faith is seeking relief, going to court, and making their case. And again, we do want RFRA to extend to everybody. We think everyone deserves that opportunity, but it is continuing to serve the groups it intended to.
Thank you, Mr. Chairman. I yield back. I yield back to Mr. Thompson.
Thank you. Gentlelady from Oregon, Ms. Bonamici.
Thank you, Mr. Chairman and Ranking Member. Thank you to all of our witnesses. Ms. Laser especially, I followed the work of the Americans United for Separation of Church and State for years, and I commend you for so capably filling the very, very big shoes of Barry Lynn. I'm from Oregon, so just for the record, the full title is Employment Division of Oregon versus Smith. It's a case that originated in my home state. I also chair the Civil Rights and Human Services Subcommittee here on the full committee, and I'm deeply concerned about the Trump administration's efforts to roll back individual rights and liberties under the guise of protecting religious freedom. And as we've heard from our witnesses this morning, the intent of the original Religious Freedom Restoration Act was to protect the rights of religious minorities, not to use religion to somehow justify discrimination against women, communities of color, LGBTQ individuals, and other minorities. So, Reverend Hawkins, thank you for emphasizing the importance of protecting personal religious views. And just to follow up on Ranking Member Fox's question about the number of cases brought by corporations, I mean, to me, it's because corporations don't have religious beliefs. They're corporations. That was always baffling to me about the Hobby Lobby case to begin with. But Reverend Hawkins, in your written testimony, you said, legitimizing these kinds of claims as cases of protected religious freedom would undermine years of progress in state and federal civil rights and anti-discrimination law. The key distinction lies in the choice being limited or projected. Personally choosing not to have an abortion or use birth control, for example, is religious freedom. Making that choice for someone else on the basis of one's own religious principles is religious oppression. I couldn't agree more with the way you phrased it. And how have the examples, Reverend, how have the examples we've discussed here today show that RFRA is being used not just to protect personal views, but to infringe on the views and beliefs of others?
If I am an employer and I have the power to determine who gets hired, who does not get hired, who gets fired, I have power over that individual. And therefore, I can use my religious views, my beliefs, to try to influence them in a way that goes beyond the quality of work that they are performing. We all have religious freedom as individuals, and like you, I kind of question about whether corporations have religious views. They really reflect the religious views of the individuals who are in charge. So I cannot do anything in my personal faith walk to harm another person. I can't allow my religious views to say that, well, you're right and I'm wrong. And because every religious view is limited. Every person, no matter what denomination you belong to, there are strengths and weaknesses within that faith system. So we have to be careful, especially when we try to determine who is righteous and who is Christian, who is non-Christian, and impose our beliefs upon them.
Thank you. And Ms. Laser, I'm deeply concerned about this administration's ongoing attacks on women's health and women's right to make their own reproductive health care decisions. And as we've heard today, without appropriate safeguards, religious liberty can begin to subvert the rights of other people. And I look at Title X, for example, the Family Planning Program, the nation's dedicated source of federal funding for family planning. And annually, Title X health centers provide high-quality family planning and sexual health care for 4 million predominantly low-income people. In 2017, in my home state, nearly 45,000 Oregonians got life-saving preventive health services, breast and cervical cancer screening, testing and treatment for sexually transmitted diseases, HIV testing, contraceptive services, supplies, and information. And yet now under this administration, this very successful program is in danger. I look at this domestic gag rule that basically eliminates comprehensive pregnancy options counseling, and the result is the government telling doctors and nurses how to do their job. And essentially, the rule is bending over backwards to appease anyone or entity who's opposed to women's access to comprehensive health services. So, Ms. Laser, are we seeing a pattern by the administration when it comes to attacks on women's health, and how is religious liberty being used to compromise the health and safety and decisions, personal healthcare decisions of women?
Yeah, we definitely are seeing that sort of pattern that you're alluding to. In addition to the Title X issues, and I'd always like to remind people that Title X was signed into law by President Nixon, actually originally. We're also seeing the attacks on women's health in the form of the final regulations on birth control that we've been talking about that would allow all bosses to deny access to affordable birth control to their employees, universities to deny access to birth control to students. We actually have brought a lawsuit against the Trump administration in Notre Dame on behalf of a group of students at Notre Dame who are seeking affordable birth control there, but their options are being limited by the university. There is also recently the denial of care rule that the administration issued that would allow everyone associated with the medical industry, from the scheduler to the doctor, to turn away patients, even in cases of sort of life endangerment, based on their moral and religious views. And that would also definitely impact women, a woman showing up needing to terminate an ectopic pregnancy that's endangering her life could be turned away based on the denial of care rule. Then we've got the proposed rule for 1557, the healthcare law that we were talking about, that the landmark legislation that put a sex discrimination prohibition into federal healthcare law that would undermine those protections, erase gender identity and sex stereotyping entirely from the regulations, and allow for another gaping hole, like you're referencing, religiously affiliated hospitals and insurance companies to have a religious exemption when it comes to the sex discrimination provision.
That's very concerning, and I see my time has expired. Thank you, Mr. Chairman. I yield back. Thank you for your testimony.
Thank you. Gentleman from Michigan, Mr. Wahlberg.
Thank you, Mr. Chairman. And thank you to the panel for being here. Mr. Sharp, thank you for standing firmly for American values, constitutional values, as a lone voice in many cases, for what we just took for granted in a union that wasn't perfect. In fact, this union, as our framers and founders said, we were to make a more perfect union. That's a continuing effort that we have to do. For the other members of the panel, again, thank you for being here, but your testimony is troubling to me. As I sense that I'm to acquiesce in my faith. My faith is personal. I don't push it on anybody else. But my faith says to me that I should take God at His word and act accordingly. And my God says I'm to love all. Those He loves, I must love. But what He condemns, I cannot condone. Again, that's acts, that's philosophies, that's values of others. I understand that. But I am a Christian first and a congressman second. My faith is not divorced from my life. And I would expect everyone else who has a similar belief, whatever that might be, that they in this country should be free. So, Mr. Sharp, thank you for standing for that. Regardless of whether we are Judeo, Christian, or any other belief, or no belief at all. That's the beauty of our country. And when we talk about diversity, if it is diversity without allowing those of us who have a strong value system based upon our faith to not express that freely, again, loving all those that God loves, but not condoning what He condemns, we have a problem in this country. Northwest Ordinance, a key principal document for our country, says religion, morality, knowledge, being necessary to good government and the happiness of mankind, schools and the means of education shall forever be encouraged. It starts with religion, morality, knowledge. Jonathan Witherspoon, a minister who signed the Declaration of Independence, said a republic once equally poised must either preserve its virtue or lose its liberty. So, Mr. Sharp, thank you for being here today and the work you do for religious freedom as a fundamental human right. I'd like to share a situation that's ongoing in my home state of Michigan. St. Vincent Catholic Charities has been serving at-risk children in Michigan for over 75 years by finding foster and adoptive parents for children in need of a loving home. Sadly, in 2017, the ACLU sued the state of Michigan to forbid the state from partnering with faith-based adoption agencies like St. Vincent, solely because of their religious beliefs. That lawsuit led the state of Michigan in March to announce that, contrary to state law, it would stop partnering with faith-based agencies like St. Vincent's. For Catholics that we've already talked about who couldn't be part of adoption or fostering and other situations. Over 12,000 children in the state of Michigan are waiting to be adopted, and the state can't find enough families to care for them. The government now is compelling this agency either do what we say and violate your beliefs, or you can't adopt children. 12,000 innocent children are being impacted. And then we find one Bethany Christian Children's Services acquiesces and gives away their faith and says we will do whatever the state says. That's a violation of our Constitution. Mr. Sharp, the government should not be in the business of enforcing adoption. I've described this one case. How would narrowing RFRA threaten charities and nonprofits across the country?
To the exact point you raised, we've got crises going on. I think this totals over 400,000 children across the country in need of a loving home. We want as many organizations as possible to help combat that crisis. But when you tell them that the cost of them serving those children is them checking their faith at the door, of abandoning those principles, it's going to dissuade them from doing so. And so at the very time we need more involved, we need laws to ensure that they're encouraged to get involved, and that if they do, they don't have to worry about the government punishing them for their beliefs. That's the type of harm that RFRA helps protect by ensuring there's a process for people of faith to have their religious.
And there's no other entity out there, whatever it is, faith or lack of faith, that can be held back from having those services available to those that they would choose?
That's right. There are numerous adoption providers throughout the state that serve same-sex couples, other couples. We want a diversity. We want a variety of groups all working together to solve this problem, and that includes ensuring people of faith are part of that.
And they should step up. I yield back.
Thank you. Gentleman from California, Mr. Takano.
Thank you, Mr. Chairman. Thank you, Chairman Scott, for holding this very important hearing on religious liberty. Liberty is fundamental. It's pre-political. It's pre-modern. It is part of our human history, and I agree, is an important foundation for public morality and personal morality. But in a constitutional democracy, one that values fundamentally not establishing one religious faith over another, religion should not be used as a shield for discrimination. When a federal contractor or a grantee receives taxpayer dollars to provide a service, they receive taxpayer dollars to provide a service. And granted, there are many, many different contractors out there. They are stepping into the shoes of the federal government. If a religious social services organization were to receive federal dollars and then also receive a religious exemption from serving LGBTQ individuals or individuals who may not be of a faith, or any number of ways in which the people's service may not be in accord with the people who run that agency, that organization would be using federal dollars to discriminate. Now, this is a huge problem, as it is in direct conflict with the strong protections the federal government has in place not to discriminate against protected categories such as race, religion, national origin, sex, sexual orientation, or gender identity. Federal services like emergency shelters, workplace training programs, and housing assistance programs are designed by federal agencies to respond to an identified need within American communities and should be free from discrimination. Now, Mr. Sharp, I'm sure you're aware of this specific example in South Carolina of foster care parents of the HHS specifically relying on RFRA as a justification to grant them a waiver to allow them to discriminate against LGBTQ parents who want to adopt or take in foster children. So they're relying on RFRA as part of their justification. They're receiving federal dollars. Do you think it's right for a religious organization that does not believe in serving LGBTQ individuals to be allowed to take federal dollars and then also discriminate against certain categories of people, including LGBTQ people?
Thank you for that question. One of the beauties of RFRA is that it does not pick winners and losers. It's that process, that balancing process. And so when we talk about the specific context of adoption providers, there are a lot of interest involved. There's the interest of the birth moms. For many of these women, this is the last decision they're going to get to make over their child. And they may have a conviction about having their child raised consistent with a particular religious faith or a particular type of family. There's the interest of the child involved. There's the interest of the provider as well, of ensuring that they have an open door to allow them in. So what we're focused on is ensuring that there's that process, that all of these balancing can occur between these interests, not guaranteeing an outcome, but just allowing them to have that opportunity.
I understand that, but should any organization that takes federal dollars, in this case, an organization that's an adoption agency, should they be allowed to discriminate against people who are maybe LGBTQ or people who are non-believers?
Yeah. And again, I would say two things. Number one, part of RFRA is that it's a very fact-specific analysis. It's what Justice
I understand you're referring to RFRA, but I'm asking a very specific question. In principle, should that, as a policy, should they be able to, after receiving federal dollars, federal taxpayer dollars, dollars that are intended for a certain need, should they be able to discriminate against any number of categories of people?
And again, I'm gonna go back, but RFRA is about balancing all of those interests, and we have to ensure that the interests.
I'm not asking you about RFRA right now. I'm asking you simply, should that be allowed to occur? Should we, as a matter of policy from the federal government, allow anyone to receive federal dollars and then have that entity go ahead and discriminate against American citizens or Americans?
I think we want to ensure that every religious organization.
Mr. Sharp, I think the answer is very simple, and you're dancing around it. Ms. Laser, can you answer that question?
Here's the thing. So you can't have it both ways. If faith-based groups want to be eligible to receive government funding to perform government services, then they have to play by the same rules as everyone else. We have anti-discrimination laws in place because those are our shared secular American laws that we've passed. We've come together, and democracy brings all of our different faith views together. When I worked for the Religious Action Center of Reformed Judaism, I brought a Jewish perspective to you all to argue for laws to become a certain way based on Jewish values. But the democracy process translates those values into shared American values, values that we can all live under, that we can peacefully coexist in such a diverse, religiously pluralistic society that we are. Religion should not be used to carve out exceptions from where the government has committed to providing services to people in need. And the Establishment Clause makes clear that that's not how religious freedom is intended through a line of Supreme Court cases. So the answer is no.
Mr. Chairman, my time has run out. I thank you for this hearing.
Thank you. Gentleman from Kentucky, Mr. Guthrie.
Hey, thank you. Thank you all for being here today. I appreciate it very much. Mr. Sharp, constituents across my district come from various faith backgrounds. Can you expand on how the Religious Freedom Restoration Act does not favor a particular religion, and can you elaborate on how detrimental the Do No Harm Act would be to all individuals willing to express their religion?
Thank you for that question. The Religious Freedom Restoration Act was both enacted and has been used by a diverse array of religious groups. As I discussed earlier, from Muslims and Christians and Catholics to Rastafarians and Sikhs and humanists and so many others, it is continuing to be used by a very diverse group of individuals who all simply want to ensure that if a government regulation burdens their ability to live out their faith, and I do believe that every religious organization should be free to live consistent with their faith, that they have a process to go seek judicial relief. What the Do No Harm Act is takes away that opportunity for relief, shutting the doors of the courthouse to a lot of individuals, organizations, if their claims fall out of disfavor, if their claims are now exempt under the Do No Harm. And I think it's very clear looking at the Do No Harm what it's meant to go after. It's meant to go after a lot of the unpopular outcomes recently, a lot of the unpopular things we see religious groups doing. But I think in a time like that, RFRA is more urgent than necessary to ensure that the political whims don't dictate whether an individual or organization's faith is respected.
Okay, and a follow-up on that, without the Religious Freedom Restoration Act, would faith-based groups need to ask for exemptions from every law or draft legislation that could unintentionally take away their freedom?
I think that is exactly one of the issues, is imagine where a government regulation comes along and you've got a small congregation, a small group of believers. They don't have the power to go and request that. They don't have the lobbying. They don't have the support to do that. And so what's going to happen is that they're going to be steamrolled by this government regulation. What RFRA does is that if such a regulation passes and a powerless group finds themselves subject to it, they now have a safety valve, a way to go to court and say, Judge, this is violating our beliefs. These are our sincerely held religious beliefs. And the government can show up and explain why it's got a compelling interest, but it ensures that they've got a process for justice.
Thank you very much. And that concludes my questions, but I will yield the remaining of my time to the ranking member, to the Republican leader.
I thank the gentleman from Kentucky for yielding. I have a question, Mr. Sharp, but I'd like to make a couple of statements and then see if you agree or disagree. Number one, I want to emphasize over and over again a very important statement you made. Disagreement is not discrimination. In our beliefs, we disagree. But that does not mean we're discriminating. And in my opinion, disagreeing doesn't mean I'm imposing my beliefs on you. So I totally disagree with the statement that by disagreeing, I'm imposing my beliefs on someone else. Also, it's been said we can't have it both ways. Well, it seems to me the very act that created RFRA undermines that. Those people wanting to smoke peyote, the government said it's okay because it's part of their religious belief. So it seems to me the very thing that created RFRA has undone all these comments we've heard from others. But let me go back to my question, and if I've said anything wrong, please correct me. I was struck by the statistic in your testimony, courts rule in favor of the government in over 85% of RFRA cases. So the government wins 85% of the time. Does this suggest to you that RFRA is being used to make sweeping changes to society, or does it merely provide an opportunity to argue for a religious exemption in court in the most efficient way that we currently have?
The latter. RFRA is providing that opportunity to seek relief from government regulation. And I thought Chief Justice Roberts' words in O Centuro were very apt. He said, I trust the judiciary to be able to weed out the cases, to see when there's sincerely held religious beliefs that are being burdened and when there's frivolous claims. And I think what we're seeing is the judiciary is capable of doing that and is doing a great job, while also simultaneously ensuring that when we do have regulations that truly infringe upon religious liberty, relief is available.
Thank you, and I make one more comment. We've heard the word comprehensive health services used here. It is my understanding that Planned Parenthood is happy to encourage women to have abortions, but never discuss with them that they can keep their child and put it up for adoption. That's not comprehensive. I yield back to the gentleman from Kentucky.
The gentlelady from North Carolina, Dr. Adams.
Thank you, Mr. Chairman, and to the ranking member as well for convening today's hearing, and to the witnesses, thank you very much for your testimony. Many of us on this committee are too familiar with the alarming statistics on maternal mortality in this country. The problem is particularly alarming among Black women who face maternal mortality rates that are 3 to 4 times higher than their white peers. And that's why my colleague, Congresswoman Underwood, and I founded the Black Maternal Health Caucus just a month or so ago to focus on this issue and on the disparities that we're seeing. Now, given this focus, I am concerned that the Trump administration's rulemaking, which will allow health providers to deny care to pregnant women, will only exacerbate the maternal mortality crisis that we're facing. Studies have shown that Black women already receive lower quality obstetric care, and many experience maternity care deserts, meaning they live in counties where access to maternity care services is limited or absent. Ms. Wiltshire, how do you believe the Trump administration's final rule on refusal of care will impact the ability of Black women to obtain quality medical care?
Again, my focus is employment, but my view is that we are concerned about the implications of RFRA on a number of fronts, and concerned about the issues related to African American women in care. I mean, just because we've been watching that.
So ultimately, how do you think the rule will impact the rate of maternal mortality among Black women?
We are concerned about the rate of maternal mortality, and this administration, in many ways, has done things that have had a deleterious impact on people of color, and particularly in the healthcare field. So I wouldn't be surprised.
Okay. To follow up, in your opinion, do you believe that the rulemaking would delay emergency care for pregnant women who desperately need certain services or procedures, or face a lost pregnancy, or even their own death?
Well, rulemaking it would have an impact in terms of delaying individuals receiving services, most definitely, and that has real human consequences.
Thank you. I think it's important, Mr. Chairman, to note that the Trump administration's rules do not protect anyone's freedom, as far as I'm concerned. If anything, it takes away freedom from the millions of women who need life-saving care. The attacks on Title X and on the ACA's contraceptive mandate and on ACA's anti-discrimination protections are an attack on the civil rights of millions of Americans. That's just plain and simple. So if anything comes out of this hearing, let it be that message. So before I yield back, Mr. Chairman, I'd like to submit for the record an article from the American Civil Liberties Union that tells the story of Tamisha Means, a Michigan resident who almost died when her local hospital turned her away after they refuse to provide abortion services. And Mr. Chairman, I'm going to, I'll yield my time back to Ms. Hines. Ms. Hayes, I'm sorry, Mr. Chairman, I'll yield my time to Ms. Hayes. Thank you. Mr. Chairman, can I submit for the record this article which from the Deputy ACLU Reproductive Freedom Project?
Without, gentlelady from Connecticut.
Thank you, Mr. Chair. I just have a question really quickly for Mr. Sharp. Very briefly, do you believe that ensuring all children are provided with a loving and safe home is, as you put it, a draconian rule?
No, I believe providing every children with a secure and safe home is part of what motivates the importance of protections like RFRA to ensure that a diversity of providers feel free to go in without having to compromise their faith is the price of helping to serve these children.
Okay, do you think that single mothers are unfit to provide a home to foster children?
Yeah, I personally don't. But I also understand that there are many birth mothers who may wish for their child to be placed in a home with a mother and father, that that's what they want best. There may be other considerations involved, and we want to take all of those into the balance when we're looking at how RFRA applies and how these faith-based providers, birth moms and children, all of their interests should be protected.
Perfect, thank you so much. I'll come back during my line of questioning.
The gentleman from Alabama, Mr. Byrne.
Thank you, Mr. Chairman. Mr. Sharp, I am going to read you a few quotes regarding the Religious Freedom Restoration Act. First quote, without the Religious Freedom Restoration Act, the fundamental religious rights of all Americans to worship as their consciences dictate will remain threatened. Any idea who said that?
I don't.
That was Judiciary Chairman Jerry Nadler. Second quote, the founders of our nation, the American people today, know that religious freedom is no luxury, but is a basic right of a free people. RFRA restores the First Amendment to its proper place as one of the cornerstones of our democracy. It is simple. It states that the government can infringe on religious practice only if there is a compelling interest and if the restriction is narrowly tailored to further that interest. Any idea who said that?
A person of great wisdom.
Senate Minority Leader Chuck Schumer. Third quote, after Employment Division versus Smith, more than 50 cases were decided against religious claimants. Amish farmers were forced to affix garish warning signs to their buggies, despite expert testimony that more modest silver reflector tape would be sufficient. Orthodox Jews were subjected to unnecessary autopsies in violation of their family's religious faith, and one Catholic teaching hospital lost its accreditation for refusing to provide abortion services. RFRA is an opportunity to correct these injustices. Any idea who said that?
No, sir.
Majority Leader Steny Hoyer. Mr. Chairman, I ask unanimous consent to insert into the record a copy of the House floor proceedings from passage of the Religious Freedom Restoration Act in 1993. You know, I wish my colleagues would actually go back and read the congressional record from 26 years ago.
Without objection.
Thank you, sir. Back then, Republicans and Democrats alike were united in a belief that the fundamental right of the free exercise of religion was worthy of the highest level of judicial protection. Congress did not enact a guaranteed win for people of faith, but restored, as you said, a balancing test. The religious individuals or organizations exercise against the government's compelling interest in restricting that activity. As we've already heard today, the government's winning over 80% of the time. Yet the few wins for people of faith that they've gotten in recent years have really upset the majority. This hearing is titled The Misapplication of the Religious Freedom Restoration Act. But it should be clear to all that RFRA is being applied exactly as it was intended. The difference is not the law. It is in my Democratic colleagues' point of view since 26 years ago. Frankly, this committee should question why we are even considering taking away the rights of citizens to freely practice their faith. This legislation does not live up to the ideals of our great nation's Constitution. And we need to stand up for people of faith who are under attack in America today. There is a fundamental conflict in values in this country, and there is a determined minority, an intolerant minority, that would tell the majority in this country who are people of faith, you cannot exercise your faith because we find it repugnant in some way. Well, that's not what the Constitution is about. That's not the reason this country was founded. This country was founded so we could all freely exercise our religion. It is not a secondary right. This bill, and I have tremendous respect for the sponsor of this bill, in essence, would make everybody's right to freely exercise their religion a secondary thing. Well, to millions, tens of millions of Americans, it is the primary source of their meaning in life. And they would take that away from them. For what? For a handful of cases that have gone the other way, when 80+% have gone the government's way. That's how fundamental the conflict in values in this country has become. And we in this Congress should stand up for the majority of Americans who have Judeo-Christian values and say you can continue to exercise your faith. And we, the government, are not going to take that away from you. With that, Mr. Chairman, I yield back.
Thank you. The gentlelady from Washington, Ms. Jayapal.
Thank you, Mr. Chairman. I think we have to stand up for everyone's religious freedom, not just those with Judeo-Christian values. The right to religious freedom is a foundational value of the United States of America, and it's enshrined in our Constitution. To ensure those freedoms are protected, the Religious Freedom Restoration Act, also known as RFRA, was introduced 25 years ago. And we have heard today, through many of you that have testified, the concerns about the Trump administration's co-optation of RFRA and the idea of religious liberty as a tool to threaten basic human rights of LGBTQ Americans, women, religious minorities, and other vulnerable communities. Religious exemptions should never be used to override those non-discrimination provisions in any venue, and certainly not in the area I want to focus on in my questioning, in the area of health care. And that's why the Affordable Care Act contained important provisions that protected people from discrimination on the basis of race and color and national origin, sex, age, or disability, as well as ensuring that employer-sponsored insurance plans would provide adequate contraceptive services with no cost sharing. I have to tell you, I have watched in horror as I have seen the Republicans and Trump administration strip away those exact health care protections, leaving millions of Americans vulnerable to discrimination or denial of access to critical health care services. And there has been an attack on Americans' health care by abusing RFRA as a basis to discriminate against women, for example, who are seeking access to reproductive health services. Recently, I shared a very personal story, the first time I'd ever done so in my life, to highlight why women have to be able to access the reproductive health care services they need. For me, making a deeply personal choice about abortion was a difficult enough choice on its own. I cannot imagine how much more difficult that choice would have been had I been denied care due to discrimination. So, Ms. Lazar, I hope I said that right. Your testimony highlights how the recent rules in the Trump administration are contributing to discrimination in healthcare, and particularly for access to reproductive health services. Can you please describe why access to reproductive health services is critical not only for women's health, but also for furthering women's equality?
Thank you for that question, and thank you for your beautiful op-ed on your own story about your own reproductive freedom needs. Really appreciate it. Sure. Contraception. I mean, it sort of boggles my mind that we're in 2019 and still needing to talk about why contraception is important to women. When the Affordable Care Act passed, they actually delegated to the Institute of Medicine the decision about what's preventive health care and what's not, what's that important that it needs to be covered. And the Institute of Medicine said all forms of contraception need to be covered because that's preventive health care. Women use birth control for a variety of different reasons. One of them is medical. Lots of women, 30%, use contraception, at least in part, to manage a medical condition like endometriosis, ovarian cysts, chronic migraines, and menstrual disorders. Some women also have medical needs to use different forms of contraception. For example, breast cancer runs in my family, so contraception that is hormonal-based isn't advised. There are very important social and economic status needs for women to be able to use birth control, and I am a huge fan of children. In fact, 2 of my children are sitting behind me today, right over here. Oh, no, they left. My husband's still here, but they left. That's terrible. But in any case, I have 3 children of my own. But it is very important to be able to plan when you have them so that you can stay in school, for example. There are studies that show that women are much more likely to find themselves in poverty if they have to drop out of school when they weren't planning to have a child. It enables women to be equal participants in society. They say that most women not using birth control would have 12 to 15 children in the course of their lifetime.
Let me ask you specifically about unintended consequences, or perhaps intended consequences, of allowing employers not to provide contraception. You've spoken to the broad range of issues very well, and your children should be proud of you. But so let's talk about employer plans for a second, and those unintended consequences.
Sure. Unintended consequences?
Or intended, however you want to take it.
Lots of women who, or transgender men who work for employers who are imposing their own religious views on women, despite what our shared American laws say, which is that all contraception has to be covered with no cost sharing, are suffering because they can't afford contraception. And that's what we've heard from the students at Notre Dame, at Irish for Reproductive Health. Some birth control can be very expensive. Like an IUD can cost $1,000 or $1,200 and can be really cost prohibitive. Women have to decide between childcare and birth control, between putting food on the table and birth control. These are very dangerous decisions that women make because they can affect women's health, as we've discussed. So when an employer just decides to impose his or her religion on the women in need who are working for them, despite what's promised by our shared American law and our best medical judgments from the Institute of Medicine, that's putting women's lives and health at risk, but also women's economic and social status.
Thank you so much. I appreciate that. I see my time has expired. I yield back.
Thank you. The gentleman from Indiana, Mr. Banks.
Thank you, Mr. Chairman. Today's legislation and hearing show so many of us just how much times have changed. In 1993, RFRA passed both the House and the Senate with near unanimous bipartisan support. Then Representative Chuck Schumer was the lead sponsor in the House of Representatives, while Senator Edward Kennedy carried the bill in the Senate, where it received 97 votes. When President Clinton enthusiastically signed the bill into law, he noted how a, quote, broad coalition of Americans came together to make this bill a reality. Mr. Chairman, the 1990s weren't exactly a time of bipartisan unity. Yet, despite the intense political debates that took place, Republicans and Democrats came together to protect the religious freedom of all Americans. Religious liberty remains the bedrock of the American experiment, and Republicans remain firmly in favor of RFRA protections. Unfortunately, my friends on the other side of the aisle are fighting tooth and nail to eliminate religious liberty and advance the radical pro-abortion agenda by rolling back common sense conscience protections. My first question is a simple yes or no question. And Ms. Laser, I'll start with you. Do you think doctors or nurses should be forced to participate in abortions? Yes or no?
That's a more complicated one.
That's what I thought you would say. Ms. Wiltshire, do you think that doctors or nurses should be forced to participate in abortions?
As my colleague said, it's complicated.
Reverend Hawkins, do you think doctors or nurses should be forced to participate in abortions?
Should be forced again?
Should be forced to participate in abortions.
I don't think they should be forced.
Okay. Mr. Sharp, do you think doctors or nurses should be forced to participate in abortions?
No.
Thank you. Mr. Sharp, as you testified, Congress intended RFRA to serve as a balancing test, not picking winners or losers, but respecting the faith practices of all Americans. RFRA does not allow the federal government to burden religious practice unless it can prove that it has a really good reason or a compelling interest, and that the government's purpose is accomplished with as little a burden as possible on the individual. This balancing test has been instrumental in numerous U.S. Supreme Court decisions. Take, for example, the Zubik versus Burwell decision, where a unanimous court ordered that the government stop penalizing the Little Sisters of the Poor, an order of Catholic nuns for choosing health care that meets their needs. Or the 9-0 U.S. Supreme Court decision Holt versus Hobbs case, which permitted a Muslim inmate to have a half-inch beard. Mr. Sharp, do you think the Supreme Court was wrong in those decisions to uphold religious liberty?
No, I think they did exactly what RFRA was designed to do: protect religious liberty, provide people of faith an opportunity to get relief.
Okay, and as a follow-up to that, Mr. Sharp, who is best to define what the tenets of the Catholic faith are? The government or the Little Sisters of the Poor?
The Little Sisters of the Poor.
Go ahead and expand on that.
We should all be worried when the government has the authority to determine what a particular faith believes or whether certain beliefs are consistent with the faith. There's been numerous Supreme Court decisions on that exact issue. We want religious individuals who have a duty to the omnipotent being that they serve to alone be responsible for determining what they are compelled to do, what they feel that their faith defines them. And what the government's role is to provide broad protections for that belief so that those individuals are not forced to do something that they believe violates those deeply held beliefs.
Okay, thank you. With the time I have remaining, I'll yield it to Dr. Fox.
I thank you, Mr. Banks. Mr. Sharp, in August 2018, the Department of Labor's Office of Federal Contract Compliance Programs issued a directive to provide guidance to its staff and federal contractors on enforcement and compliance. The directive summarized Supreme Court rulings that the government must permit individuals and organizations, with rare exceptions, to participate in government programs without having to disavow their religious character. Are you familiar with this directive, and did it accurately characterize the law?
Yes, I am. In fact, it was motivated in part by one of ADF's cases, Trinity Lutheran. It involved a preschool program that wanted access to shredded tires, playground mulch, so their little kids at the program don't skin their knee when they go down a slide. And despite checking all the boxes and satisfying all the requirements, they were denied from participating in that government program because they were religious. No religious contractor should be subject to the same thing. They should all have equal access.
Thank you very much. I yield to the gentleman from Indiana.
The gentleman from New York, Mr. Morelli.
Thank you, Chairman Scott, for holding this important hearing today, and to all our witnesses for being here this morning. I want to pick up a little bit on what Ms. Jayapal's testimony or questions were about. I've had the privilege of serving on this committee since January this year. In those 6 months, my colleagues and I have sat in this room and heard from multiple witnesses who are expert on a number of issues related to health care. And they've allowed us to respond to the parade of ways that the administration has attempted to undermine the Affordable Care Act and roll back protections for millions of Americans. In February, we talked about the 102 million people who, prior to the ACA, had lifetime limits on their health plans. People would have to pay for high-cost medical conditions like cancers out of pocket should the administration be successful in attempts to repeal the Affordable Care Act. In April, we held a hearing on short-term, limited-duration health insurance plans, a form of health coverage that is a poor substitute for comprehensive insurance. And today, it's discussion, the use of the Religious Freedom Restoration Act, which other people have opined on and described, to hack away at the stability of the ACA. I find this horrifying, but hardly surprising. Since 2017, we've seen countless attempts and efforts to roll back our healthcare system on LGBTQ and patients in other marginalized communities. And I wanted to get some thoughts about this. In 2016, the Obama administration finalized regulations to ensure that civil rights protections under Section 1557 of the Affordable Care Act apply to a wide range of entities that receive federal funding, including hospitals, insurance companies, government entities, and other organizations. Last month, the Trump administration proposed a rule which would entirely remove a definition for covered entity. Ms. Laser, can you share your assessment of the Trump administration's decision to seemingly scale back the number of entities to which Section 1557 applies?
Sure. So it is my understanding that the proposed rule would change who has to comply with 1557 and limit the number of insurance plans and the number of federal health programs that have to comply, which would drastically change the scope of existing non-discrimination protections, further limiting access to health care. That would be the effect. Furthermore, under the proposed rule, religiously affiliated hospitals and insurance companies can exempt themselves from the sex discrimination requirements in this provision. So it is another regulation in the name of religion that is turning back rights and protections that the American people have decided to give to vulnerable communities.
And while it's true that most of the conversation today, as I followed it, is really centered around reproductive rights, the truth is that you can use a religious exemption to anything that you ultimately decide, even though it discriminates against someone, might apply to your religious freedoms. I mean, you know, new religions can pop up, and you can have all kinds of things in relative to healthcare that a religious group would find objectionable to, and there are some religions that object to medical care entirely. So certainly, while we have talked about reproductive rights understandably and necessarily, it's certainly not limited to that. I wanted to just get, again, Ms. Laser, from you, your thoughts on this. In January of last year, the Trump administration created a new Conscience and Religious Freedom Division within the Office of Civil Rights at HHS. I'm just wondering, are you aware of any initiatives the division has undertaken over the past year that have improved access to health care for marginalized communities?
I'm aware of none. In fact, quite the contrary. It's my understanding that this is the division behind the denial of care rule that I spoke about earlier, which would decrease instead of increase access to health care for marginalized communities.
And are you, in your opinion, was the division necessary to protect the so-called rights of healthcare workers?
No, because those rights were already being protected by the Office of Civil Rights at HHS even before that. HHS has successfully protected those interests as defined by Congress, and no, that was being taken care of.
Very good. Thank you, Ms. Sherry. Yield back my time.
Gentleman from Texas, Mr. Taylor.
Thank you, Mr. Chairman. Appreciate this hearing, appreciate the witnesses. So just a quick question. Does a parent have the right to raise their child in their faith? Does a parent have that right? I mean, does a Muslim parent have a right to raise their child as a Muslim, Christian parent as a Christian, Jewish parent as a Jew? I mean, does that seem reasonable to you? Yes or no question. Does that seem reasonable to you?
Absolutely.
Does that seem reasonable to you? Just going down the line here.
Yes.
Yes. Does it seem reasonable to you?
Yes, as long as that faith does not impact others negatively.
All right, okay. So in that vein, I think if we begin that fundamental parental right for faith, it seems reasonably that a Catholic parent who's giving their child up for adoption should say, I want my child to be raised as a Catholic once they're adopted. I think if we're going to begin with that fundamental right of a parent's decision about faith, that faith should extend even if they give the child up for adoption. And I think that applies for, and I happen to represent a very diverse community. I live right next to the largest synagogue in Collin County. We actually have the largest mosque in North Texas in my district. I have a very large Hindu community in Frisco, Texas. And I want to defend all their faiths. I want to defend their ability, those parents' abilities. If they decide that they don't think that they can raise the child, that they want that child to be adopted, that they should be able to choose a faith-based organization to raise their child in the faith of their choice. And I think that RFRA is something that defends that. It defends a very basic premise that we all agree with here, right? We all agree that a parent should choose the faith of their child.
But
and so when we think about in Texas, I have a 100% meeting policy. I meet with all my constituents. I've had 250 meetings so far in the last 6 months. It's been pretty busy. But in those meetings, I've actually had the opportunity to meet with community leaders who are working on foster care. And they tell me that while we have lots of beds in Collin County, other communities are using those beds, and so are for foster care. And so it's so important to have as many possible foster care opportunities as possible. So having religious-based foster care organizations increases the opportunities. More beds, it's better for the children. And so, Mr. Sharp, can you just speak to that? I mean, like the need for having foster care and for people to be able to make religious choices about their children, even if they're not raising their children?
Yeah, absolutely, and I think that highlights the importance of RFRA and the harm of do no harm. When you have a birth mom that reaches out and says, I would like my child to be raised consistent with this faith, an adoption provider that tries to honor that request under do no harm could now find themselves facing government restriction and punishment for trying to honor the interest and request of that birth mom. But under RFRA, that faith-based provider has the opportunity to go into court and say, we're representing the interest of the birth mom, wanting to protect those parental right interests and ensure that her wishes are respected. And so they get that opportunity to go in court and make that case, and that's so important.
No, and I appreciate that. I think RFRA really does protect all faith communities. And again, I have the privilege of representing a very diverse community with many faith communities. And as I talk to the people that care about children, that this is an extremely important fundamental piece of statute. Certainly in Texas, we've worked to preserve the ability so that we have as many choices as possible for parents, whatever their faith may be, to protect a right that I'm glad to see we all agree that parents should be able to choose the faith of their child. I yield the balance of my time to the ranking member.
I thank the gentleman from Texas. Mr. Sharp, when he signed RFRA into law, President Clinton said the government, quote, should be held to a very high level of proof before it interferes with someone's exercise of religion, end quote. Do you think President Clinton described the appropriate legal standard in free exercise cases?
Thank you, and I do. We look at freedom of speech, free exercise of a religion, freedom of the press, many of these others that are these bedrock constitutional principles that our courts have long said when the government tries to restrict those, it better have a really good reason to do so. Employment Division v. Smith undercut that specifically for religion, and RFRA restores it. And so I agree with President Clinton. This is respecting the proper place that religion holds in our constitutional system.
And just for the sake of it, we're midways into this hearing, I'm going to quote again the first part of the First Amendment to the Constitution. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That last part is often left out when people talk about our rights, and I think it's important to emphasize it. I yield back to the gentleman from Texas, Mr. Chairman.
Yield back.
Thank you. Gentlelady from Pennsylvania, Ms. Wild.
Thank you, Mr. Chairman. Ms. Laser, I feel your pain. My 2 young adult children were so scarce on the campaign trail that some people didn't believe I had kids. Moving on, I am dismayed that the questions and the answers on this very important subject seem to be falling along party lines. This is an issue that I don't believe should be partisan. The separation of church and state is enshrined in our Constitution. Sadly, I often feel that my colleagues on the other side of the aisle only have respect for one of the amendments in the Bill of Rights and perhaps only part of that amendment. In any event, RFRA restored the use of strict scrutiny as the standard to be employed by the courts in reviewing actions that may infringe on the free exercise of religion. And for the non-lawyers in the room, strict scrutiny means that the government must have a compelling government interest before imposing a substantial burden on religious exercise or in allowing the intrusion of religion in government matters. So moving on to the Affordable Care Act, which is lawfully the law of this land and was lawfully passed, Section 2713 of the ACA requires individual and employer-provided health plans to cover certain key preventive services, including all forms of FDA-approved contraceptive methods, along with prenatal care, counseling for sexually transmitted infections, and screening for domestic violence. In implementing this requirement, the Obama administration provided a very narrow exemption to accommodate certain religious nonprofit employers, such as churches, that objected to contraception coverage. But in October of 2017, the current administration promulgated 2 interim final rules that allow virtually any employer or institution of higher education to circumvent the contraceptive coverage requirement entirely. And then we have Hobby Lobby versus Burwell, in which the plaintiffs, Hobby Lobby, a closely held for-profit corporation whose owners opposed contraception based on their religious beliefs, successfully argued that they should be exempted from the ACA and its regulations requiring coverage of contraceptive care. I stress to you, it is a corporation, not a 501c3 religious institution. So my first question, and just a show of the hands here, is there any one of you who disagrees that a corporation is separate and distinct from its individual owners, officers, and board of directors? Is there anyone that disagrees with that concept? Okay, seeing none. Is there anyone that disagrees that a business like Hobby Lobby aims to make a profit? You disagree with that, Mr. Sharp, so noted for the record. Do any of you, and specifically you, Mr. Sharp, do you know what is on Hobby Lobby's website?
I believe when you look at Hobby Lobby...
No, my question is, do you know what's on their website?
I don't know everything on their website, but I know their devout belief in God is.
Well, let me tell you what's on their website, because I looked at it. It includes a link to shop departments for crafts and hobbies. It has coupons for tabletop decor, summer toys, yarn, furniture, and wearable art. There is nothing on Hobby Lobby's website that promotes the owner's preferred religion. Despite the fact that you all agree that a corporation should be treated separately from the individual owners, and despite the fact that Hobby Lobby is in business to make money and its own website makes no reference to its owner's religious beliefs, we allow that company's owners to dictate their religious beliefs upon their employees by denying contraceptive coverage to those employees. So what does that mean for its employees who are of childbearing age? Anyone of you care to answer that one? It means they can't get contraceptive coverage, right? Other than seeking alternative employment. It wasn't the federal government that was restricting Hobby Lobby's religious freedom. Hobby Lobby isn't even a 501c3 place of worship. It was really the owners of Hobby Lobby that were trying to avoid compliance with the ACA. So let me ask you this, Mr. Sharp. Would you allow a restaurant owner to forbid African Americans from sitting at the lunch counter to avoid desegregation laws?
No. RFRA has never been used that way, and if anyone attempted to, they would lose because the government has a compelling interest in eradicating discrimination based on race.
That's your opinion. Thank you. I yield back.
Thank you. Gentlelady's time has expired. The gentleman from Pennsylvania, Mr. Smoker.
Thank you, Mr. Chairman. Like the previous questioner, I come from Pennsylvania, which really was seen as an example of religious liberty of all the colonies originally. In fact, the founders who came to Philadelphia for the Constitutional Convention marveled at the diversity of religion across the city. And in what was unusual at that time, you had strong Catholic congregations, Jewish and Protestant, all operating freely and as they chose. It's still true today in the community that I represent, Lancaster and York counties, Pennsylvania, where we have people of all faiths practicing their religion in the way that they choose and doing good for the community. And so we have strong Catholic presence with Catholic charities doing a lot of good every denomination doing good. We have a strong Muslim community who have specific an organization that is dedicated to building bridges between various religions and dispelling some of the fallacies that folks hold about various religions. I'm very, very proud of that. And when my colleague mentions separation of church and state, it was never intended that we would not be a religious society. It was intended to ensure that government did not impede, did not restrict an individual's ability to practice their faith in the way that they chose. Lancaster County, Pennsylvania is home to one of the largest Amish populations in the United States. In fact, my own roots are Amish as well. And that particular community came there because they were looking to escape persecution. Protecting faith, protecting their faith as a fundamental right, protecting the faith of other groups as a fundamental right is a value that our nation has preserved for more than 400 years. And it's one that has allowed the Amish to live independently and maintain their strong core values. The Religious Freedom Restoration Act has provided more protections for the Amish by ensuring that they don't have to lobby for statutory exemptions to protect their religious freedom with each new law that is passed. And of course, as I mentioned, they're not the only religious community that have woven threads in the district that I serve. There's many, many diverse religions. Despite that bipartisan historical support for RFRA, the legislation we're speaking about today will continue down a path that my colleagues on the other side of the aisle have chartered to erode the rights that are protected by RFRA. We've seen this in the form of federal mandates that would force individuals with strong religious convictions to violate their moral beliefs, such as these coverage mandates for abortion or restrictions on parochial schools. And we have a strong community of parochial schools where parents are choosing to send their child to a school specifically because they want to see them raised up in their particular religious belief. The Amish, for instance, have a lot of one-room schools, and potentially, under this proposed law, they would need to hire a teacher who is not Amish, who may be of an entirely different faith. Time and time again, the Supreme Court has ruled that attempts to limit religious expression are unconstitutional. And in fact, I was pleased just 5 days ago, the Supreme Court ruled that the 100-year-old Blandensburg Memorial Cross is constitutionally protected. So I do have a question, Mr. Sharp. I mentioned the Amish community I represent and explained how important RFRA has been for them. If the Do No Harm Act were to be passed in the law, would the Amish community and other faith-based groups that I represent need to ask for more exemptions in every proposed piece of legislation that would potentially limit their religious rights?
Very likely so. And being small groups like that may not have political power, they may not get them. And that's why we need RFRA, to ensure those religious minorities have the opportunity to get relief.
Thank you.
Gentleman's time has expired. The gentlelady from Washington, Dr. Schreier.
Thank you, Mr. Chair. It has been really interesting to listen to this conversation. Thank you, witnesses, for your testimonies. I thought I'd speak up as the only woman doctor in Congress, because a lot of this really is revolving around women's health, and I'd like to make a couple of points. And I thought I'd start, my colleague from Indiana asked a question of all of you about whether a doctor or nurse should be forced to perform an abortion. And a few of you said it depends, and it's a complicated question. One of you said absolutely not, should not be forced to. And so I wanted to just delve into this a little bit because it is complicated, and I think that my colleagues don't really understand that let's see here, in 45 communities in our country, the only hospital available is a Catholic hospital. The treatment for an ectopic pregnancy, which is a pregnancy where the embryo implants in the fallopian tubes, totally non-viable, threatens the life of the mother. The standard treatment is a chemical abortion followed by a removal of the embryo or fetus, depending on what state it is at, typically embryo. And so when you ask that question about whether somebody should be forced to, what you're really talking about is a woman, maybe Catholic, maybe not, who goes to a Catholic hospital where the policy of those who run the hospital is that no abortions happen for any reason. Until the mother's life is threatened. And despite all standard medical care accepted, taught in all medical schools throughout this country and residency programs, that woman could get transported to a hospital where they would not perform that, where instead they would wait for her to bleed out, to risk her life before they would do what is a medically acceptable procedure, which is an abortion. So I want to be really clear that that's not a chuckle-worthy question or answer, that this is a very real question that threatens women's lives. And so when we're seeing, and I also just wanted to be really clear on this, that there is a difference between a woman of any faith who goes to a Catholic hospital seeking care, and that might be the only hospital in her area, versus a Catholic woman who goes to the hospital and chooses for her own care because of her own religious preferences to take that risk and to wait until she might be at death's door. So here are a couple questions. First, Ms. Laser, would you like to comment about any of this and your take about how this really affects women's health care and that this is not about a 20-year-old seeking an elective abortion and having a doctor forced to perform that? This is about a real medical procedure that could be life-saving. So I did not want to blur any lines there.
I actually appreciate the opportunity to say more than one word, even though I said a couple. I said it's complicated, and I don't think it's complicated where a woman's life is in danger. Then I think a doctor has a duty to do what needs to be done for the sake of the woman's life, period. And I think that what we're witnessing today is an attack on women's reproductive freedom, really, and in pursuit of what feels like it's a political agenda. And there are gaping new religious exemptions that are being created, not just with regard to abortion, but with regard even to contraception, like we talked about with the final rules, that would allow individual employers and universities to deny huge numbers of women access. So I think we're sort of living in an unbelievable moment for 2019 when it comes to women's health, regrettably.
Thank you. And then, Mr. Sharp, are you in a position where you might reconsider your answer about absolutes in this case?
Well, thank you. And on one hand, I think we can all agree that the government has a very compelling interest in protecting life. But I also, like my colleague, recognize that these are complicated cases sometimes. And what RFRA does is not pick the winners and losers. And that's not what we're trying to advocate for, but rather to provide a process so that that important interest in life can also be weighed against the doctor's concerns about doing something that violates their faith. Not picking winners or losers, but just the process for that to be discussed and considered in these complicated issues.
I believe Ms. Laser has a comment.
I think what's really being left out, though, is that the way the Trump administration is issuing regulations, they're putting their finger on the scale on one side. So RFRA does have a balancing test, and frankly, I just want to emphasize this, the Do No Harm Act doesn't change that. RFRA isn't going away. I just think it's very important that we understand that if we pass the Do No Harm Act. So I think when the government issues regulations that says any healthcare provider, anyone associated with the health system can refuse care, and any boss can refuse birth control, that is deciding, that is not balancing. Thank you.
I would agree. That's going back to the Handmaid's Tale. I've run out of time, and I wanted to thank you all for your help.
Thank you. Gentleman from Wisconsin, Mr. Grothman.
Sure. I guess I'll start with Mr. Sharp. And we're going to get a little bit beyond the statute we're discussing today, because I think America was founded, or at least John Adams said it was for moral and religious people. And I think the question is whether the government, in any cases, is hostile to a moral and religious people. Do you think America should always abide by those standards?
I agree that the government should not be demonstrating hostility towards any person of faith, whatever their beliefs may be. And that is why we have RFRA, First Amendment, and so many other protections.
Wide variety of things, and I realize many wonderful people have many different ideas on, you know, how to handle things. Right now in our country, there are a variety of programs: Medicaid, food stamps, low-income housing, TANF, Pell Grants, variety of other things, in which you're eligible for these programs if you do not get married, but you lose benefit of these programs if you do get married. Is that accurate?
I'm not familiar on all the details, but I do know there are conditions on a lot of federal programs, yes.
Right, right, given the definition of poverty. Does that bother you, or does it bother anybody else up here, that in making a decision whether to get married or not, the government weighs in substantially in favor of the decision not to get married if you have children? Does that bother any one of the four of you? Doesn't bother you?
I don't agree with that characterization about the government favoring single people, but I have absolutely no problem with the government deciding to treat unmarried people equally.
I mean, the point is it's not equal. Does that bother any of you? No, okay. Doesn't bother you, Mr. Sharp?
Well, no, I mean, and I apologize, I may not have fully understood this question, but I do think we can all agree that the government ought to be treating people equally. And that is why when a lot of these programs, especially when it involves questions of religious faith, that the religious are not discriminated against.
I think probably the most important thing most people do in their life is raise children. Right now, the federal government has a program providing free contraceptive to people, I can't remember if it's 15 or 14 years old. I think it's 14, might be 15. And as I understand the way the program works, the parents do not know if the government is weighing in and providing contraception to people, I guess usually girls that young. Does that bother you? Do you feel that's stepping on the way maybe some parents, their values? Does that bother you?
ADF is a strong advocate for parental rights and for making sure that parents are part of that process of making decisions for their child, with their child, discussing these issues and coming to resolution. And so we want to ensure that parents are always part of that process.
Okay, any of those bothered by that? Not bothered, don't care?
I'm not bothered because most young people go to their parents when they have contraceptive needs, and when they don't, it's sometimes because they're in cases of incest or other dire situations where it's better that they be using birth control than not.
A lot of times when a 15-year-old is engaged in that behavior, it's incest. I don't know, maybe it's true. One other comment here. Before it was talked about, I guess they were talking about Hobby Lobby as a for-profit corporation. And the implication is that for-profit was kind of ugly or bad. And I just will point out in my personal experience, us congressmen making $175,000 a year, I think we make more profit than most people working in for-profit institutions. And just point that out. It's not the end of the world. You know, a lot of people work for found for-profit businesses, and they don't make as much money as we do, and it's not something to denigrate if people decide to start their own business. And I'll yield the remainder of my time back to the ranking member.
Thank you, Mr. Grothman. I'd like to point out that on the Hobby Lobby website, on the page About Us, it says, "We are committed to honoring the Lord in all we do by operating the company in a manner consistent with biblical principles." So my colleague must not have gone very far in looking at the Hobby Lobby website. And Mr. Chairman, I'd like to put the About Us page in the record
Without objection.
Thank you. I yield back to the gentleman from Wisconsin.
I'm sorry, I think my time is up.
Thank you. The gentlelady from Connecticut, Ms. Hayes.
Thank you, Mr. Chair. I guess I'll just start with the Hobby Lobby question that we were just talking about and correct the record for Mr. Sharp that RFRA has been used. In the Bob Jones University versus United States, the university sought to use religion to justify its racially discriminatory admission policies. So it has been used before. Thank you to all the witnesses for being here. The subject of this hearing is extremely personal for me. I wear a cross around my neck every day because my faith is what grounds me. I am first a Christian and second a Congresswoman. There have been times when advisors or consultants have suggested that I remove my cross for fear that it would communicate intolerance or bigotry as inherent to my Christian values. I've refused. I continue to refuse because I know the good that religion brings to me, to my community, through spirit and service. I refuse because I know that my duties as a Christian are not only to preserve and spread the gospel, but to feed the hungry, clothe the naked, and be a good steward of my community. Wearing this cross does not ever give me the right to impose my beliefs upon others or to discriminate upon immutable characteristics. While I want others to respect my right to religious freedom, I hope that my cross shows them my willingness, not my intolerance, to protect the right of everyone to practice their religion or no religion at all. That is what our founding fathers said. That is what this country was founded upon. Let us not conflate the two. We heard a lot about quotes from previous legislators, but as we all know, democracy is meant to evolve. And many of the things that those people voted for years ago never even made it to the floor, which is why we have new members, new Congresses, and we continue to evaluate our role in our communities. We have passed legislation in this Congress that would have never even been considered 20 years ago. Today, so again, let us not conflate the two. Today, we've heard what happens when RFRA is abused. We see blatant transphobia, discriminatory thinking, and polarizing intolerance. This does not reflect the God I serve. I'm struck by Mr. Sharp's previous answers to my question and his comments in support of Miracle Hill or New Hope Family Services, facilities that maintain that children thrive best in homes with married couples, with mothers and fathers. This is an incredibly regressive and insulting comment, especially after having raised my own daughter as a single mom. She thrived. And this was after I received counsel from Planned Parenthood on my options and decided to keep her. She thrived. She's a married professional educator with a graduate degree, a homeowner, a conscientious and productive member of society. She too has value, and I'm so incredibly proud of her. Miracle Hill openly discriminates against foster parents based on their religion. In fact, they only place children in born-again Christian homes, which agree with their statements in support of their doctrine. I remind you, this does not reflect the God I serve. Reverend Hawkins, as a faith leader, is it not a moral issue to keep children that are eligible for adoption in the system rather than in permanent, loving homes? Should faith ever come before a child's welfare?
No, faith should never come before a child's welfare. And I really got to add that I think there's some misunderstanding about what faith is all about. Faith is not something you arrive at and you have all of the answers. Faith evolves, the word that you use. Faith continues to allow itself to be challenged. Faith, and especially following the teachings of Jesus Christ as found in the Gospels, we're called to love the Lord our God, to love our neighbor as we love ourselves. So no, faith should never prevent a child from being adopted in a loving home.
Thank you. In Connecticut, 5% of children in the child welfare system aged out without ever finding a forever home. We know that same-sex couples are significantly more likely than different-sex couples to be raising adopted or foster children. 1 in 5 same-sex couples are raising adopted children compared to just 3% of different-sex couples, and 2.9% of same-sex couples have foster children compared to 0.4% of different-sex couples. Additionally, we know that LGBTQ+ youth are overrepresented in the foster care system. many entering the child welfare system after experiencing familial rejection of their gender identity. So this is not a question, but I'll just leave it to you for consideration, Mr. Sharp. What would you tell a child who could be heading into a loving home but is being denied that chance because the home has two moms, a single dad, or that they practice Judaism or Christianity? I just want you to think about that. And one other thing to think about when we talk about people being forced to do something, if a group of firefighters show up at the Stonewall Inn and it's burning down, they can't choose not to put that fire out. Thank you, Mr. Chair. I'll yield back.
Thank you. The gentleman from Idaho, Mr. Fulcher.
Thank you, Mr. Chairman. At least a couple of my colleagues from Tennessee and Indiana brought up the difficult question about whether or not it could be possible that a physician would be mandated to perform an abortion if that was against their belief system. And most of the panel struggle with that, and it appears clear to me that that indeed would be a possibility if the Do No Harm Act were passed. Mr. Sharp, are you aware of any case or cases where the application or enforcement of the law under the Religious Freedom Act, where there's been the result of the taking of a human life?
Not that I'm aware of.
So it's also been said that the application of the Religious Freedom Act is just simply not tolerant enough. As I consider the cases that have been rendered under the Religious Freedom Act, the situation with the baker out of Colorado, didn't provide a cake under circumstances that violated his beliefs. The other one that's been talked about here a lot today, Hobby Lobby being able to decide what employee health care they are to pay for, what those services might look like. It strikes me that in those cases, the relationships involved were voluntary. The baker and those who approached that individual had options. The employees that work with Hobby Lobby have options. There's more than one employer out there. And I'll go back to you, Mr. Sharp, doesn't that at least provide an example that the law and the application of that law under the current Religious Freedom Act is indeed tolerant, and that the law under RFRA is respectful of the First Amendment and of people of all or no beliefs?
That's exactly right. I go back to a point I said earlier. Disagreement is not discrimination. And a pluralistic society means that a Colorado baker has the freedom to do, along with the countless other bakers that were more than happy to design a cake for a same-sex wedding. We can protect both, and that's part of what RFRA does, is regardless of a person's beliefs, they have that process where they can go and have their beliefs protected against government intrusion.
Thank you, Mr. Sharp, and certainly in my opinion, the existing law under the Religious Freedom Act needs to stand just as it is. I yield my remaining time to the Republican leader.
I thank the gentleman from Idaho for yielding, and I want to agree with him very, very strongly that RFRA protects people's religious freedom. But it's really clear to me today in this hearing, and I think it's the very reason why we must make sure that this bill never passes, is that many of our colleagues would impose their beliefs on others if RFRA were changed. And that's really troubling to me. Again, I want to say what Mr. Sharp has said. Disagreement is not discrimination. Mr. Sharp, the absence of RFRA, the free exercise clause of the First Amendment, would remain in effect, thankfully. Why is it important, nonetheless, to keep RFRA on the books in its current form?
Thank you, and I think we need to remember what RFRA does specifically relates to that free exercise clause. That the court's decision in Employment Vision v. Smith rolled back that strong protection for religious liberty, and it left this gap of protection. And so Congress unanimously, bipartisanly came together and said, we want to restore that proper understanding and respect for religion, insert that balancing test and that compelling interest test once again.
Thank you, Mr. Chairman. I will say again, also, RFRA is not about denying health care to women. RFRA is about protecting the First Amendment and our right to the free exercise of religion. I yield back.
Thank you.
Yield back.
Thank you. The gentleman from Michigan, Mr. Levin.
Thank you so much, Mr. Chairman, and thank you for holding a hearing on such a critical issue that impacts so many Americans' work lives and home lives. Mr. Sharp, in your written testimony, you claim that RFRA is hardly ever asserted by a for-profit business. Only 3 federal cases were brought by for-profit businesses, if I have that right. This seems like an effort to downplay the impact of discrimination by for-profit corporations. And I'd like to take a minute to set the record straight about this issue. Is one of those 3 cases you're referring to in your testimony the Hobby Lobby case?
Thank you for that question.
Is it yes or no? I don't have a lot of time.
Yes, based on the
thank
study
you.
I discussed.
Right. So in that case, the Supreme Court held that closely held for-profit employers could use religion as a justification for excluding certain forms of birth control from their employees' health insurance. Now, it may be true that this was just one case, but it's the Supreme Court after all, and I think it's important to dig a little deeper to fully understand its impact. Mr. Sharp, are you aware of how many corporations are closely held in this country?
I don't know the exact number, but I know there's quite a few of them.
Yeah, so according to the IRS, as many as 90% of businesses in this country are closely held. And these are not just small businesses. They include organizations like Hobby Lobby itself, which has 32,000 employees, Koch Industries, which has 120,000 employees. Mr. Sharp, are you aware of what percentage of Americans work for closely held corporations?
Again, I don't know the exact number, but I imagine it's a high number.
Yes, according to the U.S. Chamber of Commerce, more than half of private sector workers are employed by a closely held corporation. So I think it's deeply misleading to downplay the impact of these cases because, as we saw with Hobby Lobby, one case can impact the lives of tens of millions of people. I want to turn to you, Ms. Wiltshire, and ask you a different kind of a question. Directive 2018-03 supersedes current guidance and protocols of OFCCP, particularly regarding sexual orientation and gender identity. Based on your nearly 7 years at OFCCP, can you comment on the impact of Directive 2018-03, in particular what impact it'll have on civil rights enforcement in general?
Well, first of all, thank you for the question. It will have substantial impact depending on how again, it's all interpreted and enforced by the Solicitor of Labor as well as the Director. It has potential for having a lot of impact, particularly with the amendment that added gender identity and sexual orientation, which was to protect that LGBT community. This sort of sits back the clock, or it sets it back, and so undermines the attempt to change 11246 to protect that community.
And these recent actions of this administration regarding enforcement of religious freedom and other civil rights in line with previous administrations? And you've had a lot of experience on this.
Not to my recollection. No. I mean, I think I'd have to do more study, but frankly, in my experience, the answer is no.
And are we going in the direction of expanding the civil rights of LGBTQ Americans and others? With the Trump administration's directives? At work and in all these different areas of life, adoption and so on and so forth.
I've tried not to answer a question with no because it's complicated. The answer is, without a doubt, no. I mean, we're not going in the right direction, and we should.
Mr. Chairman, I'm both a union organizer and a faith leader. Until my sister from Connecticut talked about her personal experience, I didn't at all think of talking about mine. But I was the president of my synagogue until I ran for Congress, and I've been deeply engaged in my own faith community and in interfaith work for years. And it is just so deeply, deeply troubling when for-profit corporations and others try to use the guise of religion to violate the basic human rights of women over their own bodies, of people to employment. It's a shame, and I'm very appreciative of your leadership so we can pass this bill and correct the situation. Thank you so much, and I yield back.
Thank you. The gentleman from Texas, Mr. Wright.
Thank you, Mr. Chairman. Thank all of you for being here on the panel today. We've already discussed to some extent the First Amendment. There's a reason that the very first part of the very First Amendment and the Bill of Rights dealt with religious liberty. And as our Republican leader on the committee mentioned earlier, it starts with Congress shall make no law establishing religion or prohibiting the free exercise thereof. Reverend Hawkins, would you agree that free exercise of religion means more than the act of worship? It means that we live the faith, or try to, that we carry the faith into the public square, we don't hide it under a basket, and that we use our religious faith as a foundation for decision-making, for the choices we make in life. Would you agree with that?
Are you Presbyterian?
No, sir, I'm not.
You sound very Presbyterian. Yes, exactly. It's faith in action that makes a difference. Again, but for the betterment of others.
Okay, and thank you. And Mr. Sharp, the Constitution guarantees, again, free exercise of religion. If the federal government is restricting it, how can it be the free exercise? Can it be?
Not at all. And that is why we have the First Amendment and RFRA to provide that check against government authority.
Exactly. You mentioned earlier about disagreement is not discrimination. When you have a number of organizations, and particularly charities, that offer services, or businesses that offer services based on their religious faith, and realizing that there's so many different religions in the United States that exercise freely, they're going to do things differently from one another. It doesn't bother me that evangelicals would do something different than I would like, because I don't want evangelicals telling Catholic charities what to do, just as an example. When there are options available, let's say a bakery refuses to do what a customer might want. That's not the only bakery. There are other options. So how can they claim discrimination when there are other options available?
I think that's part of the beauty of what laws like RFRA do, is they promote diversity so that you are going to have a variety of organizations and charities all coming together for the same goal, but doing so consistent with their religious convictions.
Thank you. I would agree with that, and I would say that the title, do no harm, is a misnomer in this case, because to gut RFRA does great harm to this country. And I'm going to yield back to the ranking member.
I thank the gentleman from Texas. Mr. Sharp, RFRA is a rather simple statute that merely codifies a compelling interest test for the government to burden a person's religious beliefs substantially. It's very conformative with the First Amendment. What would happen to the effectiveness of the statute if Congress begins specifying areas of the law that will be exempt from RFRA, as Congressman Kennedy's bill, the Do No Harm Act, does?
Thank you for that question. It would have a very detrimental impact on religious liberty, because a lot of the individuals and organizations that right now are facing a lot of attack over their beliefs would find themselves deprived of the opportunity not to win, not to lose, but just to go to court and make their case, to have that fair process to explain why a law burdens their religion, and on the other side, let the government make its case as well. We want every single American of every belief, every religion, every faith, every background to have that access to that process afforded by RFRA.
And again, in order to violate the First Amendment, because of RFRA, the government has to prove its case. And that, I think, is something that perhaps had not been accentuated enough in today's hearing, as we've gone off on tangents, in my belief, and made this as though we're denying health care to women. That is not what RFRA is about. RFRA is not about denying anything to anybody except the freedom of religion. The Do No Harm bill will deny that. Thank you, Mr. Sharp. I yield back.
Thank you. The gentleman from Maryland, Mr. Hone, Mr. Trone.
Thank you, Mr. Chairman. Ms. Wiltshire, OFCCP has a long history of enforcing civil rights provisions that protect the employees of federal contractors, including Executive Order 11246, which prohibits discrimination based on race, color, religion, sex, or national origin. President Bush's 2002 religious exemption currently allows religiously affiliated entities to discriminate on the basis of religion in hiring, but specifically provides those entities are required to abide by all other provisions, for example, protections on the basis of race or sex. The Trump administration proposed expanding this exemption, but fails to reference the current exemption's limitations regarding enforcement on other protections. So based upon the data, the evidence, is there any indication that religious organizations are actually seeking such exemptions?
We looked at the compliance activity, and we haven't seen any indication of that. We'll have to talk to the solicitor, but we haven't seen it.
Exactly. During your time at OFCCP, did you receive reports or complaints from religiously affiliated organizations regarding their ability to comply with these specific provisions because of their faith? In other words, is this a directive, a solution to a problem, or a solution in search of a problem?
Well, in my experience, it's probably a solution in search of a problem. I didn't go through any of that. The executive order itself already has exemptions for religious organizations. I mean, I think, and it's worked fine. So no, to me, this is a solution in search of a problem.
Thank you. As someone deeply familiar with OFCCP's day-to-day operations, can you describe what impact this broad and vague proposal could have?
It could have quite a bit of an impact. First of all, it's one thing to have a policy in writing, it's another to apply it and to interpret it. And unfortunately, what I saw in the South Carolina case is that this administration looks to be really looking at it very liberally and broadly, which has the impact of limiting civil rights enforcement and anti-discrimination laws. So the staff, I say our as if I still work there, the staff really gets conflicted. And if they feel as though there's pressure from justice or from any other entity to read very liberally these, in terms of RFRA and the issue of religious freedom, they're going to do it, and they're going to look the other way, knowing full well they were there to enforce the anti-discrimination laws. And there is a difference between disagreement and discrimination.
Perfect.
And that's what these laws are intended to protect.
Absolutely. So even prior to RFRA, institutions whose purpose and character were primarily religious, they were able to hire based on religious beliefs. But does the Do No Harm Act do anything to change this ability to hire on religious beliefs?
No, not to my...
Perfect. Has the Trump administration gone too far and corrupted the intent of RFRA by allowing more and more exceptions and special rules, leading this law to be used as a weapon of discrimination?
My view is, from what I've seen, the answer is yes, which is why I'm here, and this is why we're really concerned about what's happening. There is the First Amendment. There's also a 13th, 14th, and 15th Amendment, and the civil rights laws that were there because of slavery and Jim Crow and segregation, because in the name of religion, those acts were justified. So yes, I suspect this administration has gone a bit too far.
We've also heard some concerns today that the Do No Harm Act would prevent religious organizations from receiving federal funding. Is that an accurate criticism?
Can you repeat that? I didn't hear.
We've heard today some concerns the Do No Harm Act would prevent some religious organizations from receiving federal funding.
No, there's no indication of that at all.
Exactly. Thank you. I yield back my time.
Thank you. The gentleman from Virginia, Mr. Kline.
Thank you, Mr. Chairman. Thank our witnesses for being here. As everyone's been discussing, the First Amendment guarantees Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. RFRA upholds this right on which our great country was founded. And the federal government has a duty to ensure that this right is not violated and that federal overreach does not infringe on the state's ability to uphold this. During my time in the Virginia General Assembly, we worked to bolster these protections for all Virginians, and I look forward to continuing that effort here in Congress. And I think one of the things that was being discussed, an important point was made, and Mr. Sharp, I'll ask you, when these individuals are being required by the federal bureaucracy to come to the federal bureaucracy and ask for some type of exemption, there's an imbalance. A notable feature of RFRA is that it requires the government to explain and justify a restriction on religious liberty. The government must show there is a compelling interest, and the restriction is the least restrictive means of achieving the interest. So is it your view that RFRA gives individuals some much-needed leverage when dealing with the bureaucracy, and does it increase government transparency and accountability in the process?
Thank you for that question. What it does is exactly you described. There are religious minorities, individuals, organizations that find themselves having their religious freedom violated by the heavy hand of government. They may not have the political power to go and seek out an exemption. So what RFRA does is provide them a process, a way to check that government authority, go to court and make their case, to explain why this burden on their religious exercise is unconstitutional, and likewise allows the government to make its case as well. Not to pick winners and losers, but to provide that check, that accountability you referenced against government restrictions on the ability of people of faith to live and work consistent with those beliefs.
And taking that one step further, how does it provide protections against rulemaking by these same bureaucracies that may intentionally or unintentionally damage the free exercise of religion?
Yes. Thank you. And a lot of times we focus on RFRA and laws, but it also extends to agency actions and things like that. Indeed, we talked about the contraceptive mandate, which, as we discussed, was the process of one of those agency actions. So RFRA simply ensures that whether it's coming from a law passed by Congress, an action by the agency, whatever the source, if the federal government is taking an action that restricts an individual or organization's free exercise of their faith, RFRA provides a check, a process for them to get relief.
Thank you. With that, Mr. Chairman, I'll yield my time to the ranking member.
I thank the gentleman from Virginia for yielding. Mr. Sharp, in most RFRA cases involving preventive services, are organizations seeking to exclude a wide range of women's health services, or are they targeting specific procedures or prescriptions that violate their beliefs?
It's the latter. We've obviously talked about that issue a lot, and I think what gets lost in the Hobby Lobby and Conestoga with Specialty, who ADF had the pleasure to represent, was that they were not seeking an exemption from all services, seeking to not cover health care, but specifically 4 items that they believed could result in the termination of a pregnancy, the loss of an innocent life consistent with their beliefs. So what they sought was that very targeted, give us breathing room so that we do not have to pay for or provide those 4 items. Not a broad array of services, but 4 things. That's what RFRA helps to do, is to provide those narrow targeted solutions.
Thank you. Mr. Sharp, RFRA sets up a balance between the free exercise of religion and potentially countervailing governmental interests. Obviously, we've heard a lot about what our colleagues think are countervailing governmental interests. We might have a disagreement on that. How would the bill introduced by Congressman Kennedy, the Do No Harm Act, affect this balance?
The important aspect of RFRA, one of its many important aspects, is it applies to any government action across the board. What the Do No Harm Act is going to narrow that, and we're going to say there's now going to be a lot of government actions that you don't have the opportunity to go to court and seek relief. Vast opportunities for people of faith are now going to be snuffed out because rather than being able to go to court and seek relief, those doors are going to be shut to them under the Do No Harm Act.
Thank you, Mr. Chairman. I yield back.
Thank you. Gentlelady from Minnesota, Ms. Omar.
Thank you, Chairman. Ms. Lasser, can you tell me the delicate balance between religious liberty and civil rights?
You know, religious liberty is about the freedom to believe what you want or not believe, and to be able to practice those beliefs without causing harm. When someone violates someone else's civil rights, they are often putting their own religious beliefs above the religious beliefs of that other person. What the First Amendment has when it comes to religion are 2 clauses, the Free Exercise Clause and the Establishment Clause. And it's important that both exist because there have to be limits on free exercise in order ultimately to protect religious freedom for everybody. That's what, and I don't feel like we've emphasized that point enough. So RFRA is about religious freedom, but the Do No Harm Act is what's ensuring that RFRA isn't being misused to take away the religious freedom of some, like Amy Madonna, who's being refused government-funded services because she's Catholic.
Mm-hmm. So let's see, religious liberty would be like a Muslim person like myself having the ability to wear my headscarf in order to serve my constituents in Congress. Yeah. Yes. Religious liberty would be a Muslim person being allowed to grow their beard because that is consistent with their faith.
Yes.
Would religious liberty be in allowing certain people to access service, like buying a cake from a cake shop?
Is that an example of religious liberty?
Would that be an example of religious liberty?
Well, I mean, if you're buying a cake for your religious wedding, I suppose you could say it's connected to your exercise of your religion. For some people, sure.
If the person denies you?
If the person's denying you that right, then what the government's doing, if the government's sanctioning that, right, because that's what's important when it comes to RFRA and the Do No Harm Act. We're talking about when the government is sanctioning one person being able to impose their religion on others. In the case of Jack Phillips in Masterpiece Cake Shop, there was a anti-discrimination public accommodations law that the state had passed. All the people had come together. It was a secular shared law. Right. And what Jack Phillips was saying is, I want special treatment. I want a special exemption from this law. If the government had given that to him, their allowing him to impose his religious beliefs on others in a way that causes harm. And religious freedom is not about causing harm to other people.
Because me exercising my religious freedom that is protected under religious liberty in our First Amendment, but imposing my faith onto you is not.
That's the point. The two clauses work together. So the Establishment Clause puts a limit on your free exercise of religion because there are a lot of freedoms. You can swing your fist everywhere, but you can only swing your fist in our society up till the tip of my nose.
Yeah.
And then that freedom is curtailed.
So a police officer, a doctor, members of Congress, we all take an oath to do no harm, yes? So if I am a police officer and there's a shooting at a gay bar, and I say, I'm not entering this place because I have a strong religious conviction that, you know, I don't believe in saving gay people. Like there was a police officer recently on a tape talking about how we should harm gay people. Would that be covered under his religious liberty? Can he do that?
No, he cannot, because it's very clear from not just the framers of the Constitution, but a line of Supreme Court cases that religious freedom is not the right to use your religion to hurt third parties or to cause harm. That's not what we mean by religious freedom. And frankly, I had a group of Stanford students who visited me, and I said, what's the first thing that comes to mind when you think of religious freedom today? And they all agreed that what came to mind was anti-gay.
And under our Constitution, we are prohibited from establishing religion, yes?
Absolutely.
Okay.
That's what the establishment
says. If you have members of Congress that are legislating laws in accordance with their faith in regards to abortion or LGBTQ or women or any of those things, that should be prohibited within our Constitution.
You are not allowed to impose, through the government, your religious beliefs on others. That is not what religious freedom is about. That's not what our country rests on.
Yeah. For many of us, religious freedom is extremely important. It is life and death in this country.
Yes.
Many of us fled our countries to come to the United States because that is the one thing that distinguishes us from many countries. But it's also important that we have a secular government and protect people's civil rights and access to those civil rights. And so I appreciate your testimony, and I yield back.
Thank you. The gentleman from Georgia, Mr. Allen.
Thank you, Mr. Chairman, and thank you for holding this hearing. This is a debate that, frankly, has been going on for 4,000 years. It's all played out in God's Word, and it continues here today. Religious freedom is the cornerstone of the great American experiment. Our founding fathers protected religious liberty as no government has in history. The Religious Freedom Restoration Act protects the unalienable rights of religious liberty for all Americans. It is a God-given right. RFRA, not the First Amendment, is the primary federal safeguard of Americans' religious liberty. In 1990, the Supreme Court greatly weakened the First Amendment's protection of religious liberty. Congress worked together to enact RFRA. Again, and I must disclose that while everything in my life, and I've been, by some standards, successful, was great 20 years ago, that I found that what was next was I'm just another broken, flawed man who cannot live without the saving grace of Jesus Christ. And that has offended some people in this room. Now, I made that choice, and I found out very quickly that when I make that statement, it is offensive, and that I cannot impose that on anyone here or in listening to my voice today. In fact, when I first made that decision, some folks called me the most dangerous person in the world. because I wanted to shout it to the world, because I knew the truth. So why is it that, we're talking today about this subject? Well, what I found out in my walk is that, I couldn't change anybody else, much less myself. And meaning that, again, I can't impose my values on anyone here or within who are listening today. All I can tell you is what I believe in. Now, that's why I think our founders created the First Amendment, and I think that's why we're here debating today, and we will be debating this for, until eternity. So I do know that Christ said there would be many false prophets. This battle has been laid out for us in the Scriptures. There are over 55 verses in the Scriptures that reference government. You can Google what the Bible says about government, and it'll give you those Scriptures. I learned that in my study of the Scriptures, which has been intense in the last 20 years, that, one of the reasons that, that I'm so passionate about this is it hadn't worked out too well for those folks who haven't followed God's laws and have been disobedient to His Word. So where are we headed in all of this? We are, the question asked by Pilate, what is the truth? Pilate was in charge of Israel at that time. What is the truth here? And we'll be debating this from now on. I've been heavily criticized in this body for telling people what I believe, and which I think is in direct conflict with the First Amendment, and I've been criticized in my district. So why do I do it? Because I do it because I believe the church has been silenced by this government, and people overall in this country have been silenced by this government and those in this government, because we're in a battle of good versus evil, and we have been for 4,000 years. Mr. Sharp, can you give me any examples of where the government has run roughshod over the church in this country, which is now unable? In fact, the church doesn't even know the truth and is afraid to tell the truth in the pulpits of America today. Can you give me some examples of that?
There are numerous ones. In fact, one I'd like to bring up was discussed earlier of Jack Phillips, our Colorado baker. The church goes far beyond the four walls, including into his business and how he operates it. What he sought was not a special exemption. What he sought was equal treatment, the same freedom that every other creative professional, every other baker in the state of Colorado had, to decline to create expression that violates his religious convictions. And so there are many other examples that ADF has represented of individuals, organizations, and churches, but we fully support the freedom of all of them to live out their faith.
Mr. Chairman, I'm out of time, and I yield back.
Thank you. The gentlelady from Georgia, Ms. McBeth.
Thank you, Mr. Chairman, and thank you for all of you that are here today. We really appreciate your testimony and your time. I am a devoted Christian, and I live very hard to walk out my faith every single day. Not that I do it perfectly, but I really try to abide by the precepts of my faith. My faith teaches me to love all people and to treat everyone equally. Never have I interpreted my religion as something used to discriminate against those who differ from me or my opinions. As my colleagues before me have pointed out, the Religious Freedom Restoration Act was not intended to be used as a means for discrimination to keep people from living the lives that they want, that they choose, as we have been witnessing recently. Whether that means having access to contraceptives, practicing their respective religion while at work, or taking in a child in need of a loving home. We should not be imparting our own life choices on everyone else. Ms. Lazar, my question is for you. I'd like to review the history of RFRA. Can you please explain for the committee why RFRA was passed and signed into law in 1993?
Sure. So RFRA was passed and signed into law in large part in reaction to the Employment Division v. Smith case. And in that case, the court changed the standard, the free exercise standard, around whether a generally applicable and neutral law could have a religious exemption if it burdened someone's religious practices. In that case, it was Native Americans in a peyote smoking ceremony and being denied unemployment benefits because of that. And a lot of folks were concerned on all sides of, the aisle, and came together, legal experts, civil liberties groups, religious groups, all sat at one big table and decided that we better make sure that we have religious freedom protections, in particular for religious minorities. So the kinds of things that came up during the debate were, what about a Jewish schoolboy who wants to wear his yarmulke to school? Or what about a Muslim firefighter who wants to grow a beard? And so those were the types of things that folks worried about. What folks weren't talking about and weren't worrying about was people being able to use religion to cause harm to other people and to discriminate against other people, people being able to impose their religion on other people. You can see those examples are very different from the types of examples that they were talking about. And that's why RFRA was able to pass with such a broad consensus. Unfortunately, though, that's not how it's played out. And that's not what we're seeing coming in spades from this administration. And so the Do No Harm Act would restore RFRA to that original intent, leave the balancing test in place, but make sure that it couldn't be misused for something that it wasn't originally intended to do and that doesn't violate the Establishment Clause of our First Amendment. So it lays out some specific areas of the law where religious freedom doesn't get to trump protections that this society has given to different groups of vulnerable people. And child labor laws, workplace protection laws, civil rights protections, healthcare, government services, and government employees like Kim Davis, being able to discriminate in the doling out of government services. That's why it's such an important and critical fix.
Thank you. Sir, if I may, Chairman, one more question. Was there any indication at the time of RFRA's passage that RFRA would allow religion to undermine the rights of others?
No, and in fact, the coalition would have disintegrated if that would have been the case. It wouldn't have passed.
Thank you very much.
Thanks.
Thank you. The gentleman from South Carolina, Mr. Timmons.
Thank you, Mr. Chairman, and I'd like to thank all the witnesses for taking the time to come before the committee to testify. We keep talking a lot about discrimination, but I want to switch gears to talk about children. Children that, for whatever reason, are in need of foster care. Over the past few decades, Miracle Hill has provided foster care for thousands of children. And while there are hundreds of other similar organizations all over the country, Miracle Hill is particularly important to me because they serve people in my congressional district. The legal issue being discussed here is that Miracle Hill requires couples seeking to foster children through Miracle Hill. They have to share the theological convictions of Miracle Hill. Miracle Hill's reasoning is that if a couple wants to be in a position of spiritual leadership to the children they care for, those positions are reserved for people that can affirm Miracle Hill's statement of faith. I want to be clear, Miracle Hill will serve any child, no matter the child's race, faith, sexual orientation, gender identity, nationality, or any other differentiating factor. And this is important. I also want to be clear, Miracle Hill has never prevented, I'll say it again, has never prevented any individual from becoming a foster parent. That is because there are other private providers less than 2 miles away from their location that would happily process any foster care application. Alternatively, someone seeking to foster children can go to the Department of Social Services, which is another mile or two down the road. So I say again, no one has ever been denied the right to be a foster parent by Miracle Hill. As circumstances may have it, Ms. Laser referenced a close friend of mine, Beth Lesser, who happens to be Jewish. And while Miracle Hill would not facilitate her fostering a child, she was able to foster a child with another nearby provider. So again, I say, no one is being denied the right to foster a child. Furthermore, Miracle Hill has never denied any individual, no matter their faith, gender identity, or sexual orientation, the right to volunteer at Miracle Hill. Anyone is welcome to volunteer in the soup kitchen. They can hand out coats and blankets. At one of the many homeless shelters they operate, they can teach adults how to read. They can help with any of another variety of the important ministries that they have. But again, longstanding policy, the policy since they were founded decades ago, if a parent seeking to foster a child wants to be in a position of spiritual leadership and influence, those positions are reserved for people that can affirm Miracle Hill's statement of faith. I'm going to speak really quickly. So we got the Catholic Diocese of Charleston. I'm going to paraphrase. They fully support Miracle Hill's ability to continue operating. The president of the Coalition of Jewish Values, Rabbi Lerner, also in South Carolina, went even a step further, and I'm going to read his because it's important. Contrary to what has been said, no one is denied the ability to provide foster services because Miracle Hill Ministries is among the agencies licensed to operate. Again, this is the president of the Coalition of Jewish Values, Rabbi Lerner. He said, any individual or family can turn to numerous other providers, including the state itself. So the loss of Miracle Hill's license would only result in fewer children served and a lack of religious support for families who share Miracle Hill's beliefs. No one would gain and many would lose, most of all the hundreds of children currently served through Miracle Hill. That is Rabbi Lerner, the president of the Coalition of Jewish Values in South Carolina. So the Jewish community and the Catholic community in South Carolina fully support Miracle Hill. My question is for Ms. Laser. In your opinion, is there any space for religious organizations that adhere to traditional religious beliefs to play a role in providing foster care services to vulnerable children, or even in the public square at all? Or should they just go to church and ignore the problems in their communities and let the government handle it?
Thanks for that question. They can absolutely play a role, and they shouldn't be excluded from being able to provide government services and act as the ward of the state, as foster care homes do for children. But when they take that on, they have to have the best interest of the child as first and foremost. That's a duty and an obligation. And that's not what's happening, because with most foster care situations, it's not a lack of foster care agencies that's the problem. It's a lack of foster parents. And there's stories from all over the country where foster kids are even sleeping on the floors of offices because they can't find foster homes, which is a very serious problem. They can be eligible to receive government money, but when they receive that money, they have to play by the same rules as everybody else, which means they can't discriminate because there are provisions in place that prevent that.
Those provisions were added by the previous administration 9 days before he left office, so I think maybe that's where we should be looking as far as the legal justification of it. I think it's safe to say that if Miracle Hill was no longer licensed, there would be less children placed in foster homes. So with that, I'll yield back the remainder of my time, and thank you.
Gentlelady from North Carolina.
Thank you, Mr. Chairman. Mr. Sharp, in the Hobby Lobby decision, the Supreme Court found RFRA applied to closely held for-profit corporations, finding that both nonprofit and for-profit corporations can advance religious freedom, which also furthers individual religious freedom. Do you agree it is appropriate for RFRA to apply to nonprofit and closely held for-profit corporations?
Yes, I do, and thank you for that question and that reminder that, as Justice Alito said in the Hobby Lobby decision, businesses are not run in a vacuum. They're run by people of faith, people with deep religious convictions. In the case of Hobby Lobby, as they put on their website, it's people that their business is not about profit. It's about honoring God, honoring that commitment to God through the work that they do. And so when these closely held businesses and organizations are involved, what RFRA does is ensures that The beliefs of those owners that are reflected in how they operate their business and how they live their lives and interact with their community, that those beliefs are given a fair hearing in court and an opportunity to seek relief from things like the contraceptive mandate and other restrictions on their religious practice.
Thank you. Mr. Chairman, in the interest of time, I will yield back and save my final comments for that time. Thank you, Mr. Chairman.
Thank you. One of the problems we have now is that the definition of victim has been changed around. We're primarily focused on generally applicable anti-discrimination laws and executive orders that direct that there should be no discrimination with federal money. Traditionally, the victims have been defined as those who are trying to get services or trying to get a job without facing discrimination. Now we're apparently trying to protect those who may be prevented from discriminating or imposing their beliefs on others. We've even heard suggestion that discrimination would be okay as long as the victim has some other alternative. They can go to another family placement. If you're denied at one restaurant, well, you just go across the street and eat somewhere else. That is not the tradition of victim in these cases. Healthcare, we've talked about the forcing a doctor against his will to provide certain services. What we didn't talk about is a child's right to a vaccination. The doctor didn't believe in vaccinations or other medical decisions. Those really ought to be up to the medical board, not to a bunch of politicians. But this case, the case in South Carolina gives us an opportunity, first one we've had in a long time, to actually discuss the situation of discrimination, because most of them tried to say, well, we don't do that. And no. They have said that they're going to discriminate in providing the way they provide services and in hiring. And Mr. Sharp, shouldn't all citizens, if it's a government-funded contract, be eligible for jobs and services under the government contract without facing invidious discrimination?
Yeah, I think we can agree everyone should be treated with dignity and respect in those situations. And I think it includes not only the recipients, but also the providers, to make sure that all of their interests and concerns are properly balanced.
Does that mean that you ought to be able to get a job at a government-funded agency without facing discrimination?
And again, I go back to, we can look at...
Wait. They said they're going to discriminate, so apparently, do you agree with that or not?
And I apologize, are we specifically referring to Miracle Hill?
Or any other agency that's taking a faith-based exemption and wanting to hire based on, and directly discriminate based on religion. You're the wrong religion, you don't get a job here. That's what Alan Yorker was told. That's what's going on. And we have an example here, live example, that people aren't ducking and dodging. That's what's going on.
Well, and again, not to duck and dodge, but for Miracle Hill as a religious organization, it is important that they be allowed to hire individuals that share that religious...
With federal money, not with federal money. They can do that with their own money. How about federal money?
I don't think we ought to condition federal dollars on the ability of a religious organization to hire people that share their faith to accomplish their religious mission.
This isn't limited, as you suggested, to just religious organizations. It's anybody with strongly held beliefs. If a bunch of white nationalists got a federal contract, could they be able to discriminate against African Americans?
Again, I said this earlier, RFRA has never successfully been used to support racial discrimination because the government has a compelling interest, as the Supreme Court has recognized, to eradicate racism.
That is a strongly held belief. Ms. Welcher, let me ask you a question on do not harm. How would that affect the administration of Executive Order 11246?
Well, as I see it, it would hold harmless the anti-discrimination provisions that exist and would not therefore allow them to be exempted or overturned, which is what's important.
And could you administer the anti-discrimination provisions of the executive order with the Do Not Harm Act?
Yes.
And what are the problems if we don't have a Do Not Harm Act? What are the problems in enforcing the anti-discrimination provisions of that law?
Again, if depending on how RFRA is being interpreted and applied, it could provide so many more exemptions than currently exist, and therefore, particularly as it relates to the LGBTQ community. And we are very concerned about that.
Thank you, and I yield for closing to the ranking member.
Thank you, Mr. Chairman. I must be honest, today's proceedings have disheartened me. It's one thing as politicians for us to debate and disagree on issue areas and ideas for how best to move the country forward. In fact, that's the beauty of this nation's political process, thanks to our freedom of speech and expression. But it's a whole different ballgame when the issue being debated is the First Amendment of the United States Constitution itself. One of our colleagues said today, we take an oath to do no harm. No, we don't take an oath to do no harm. We take an oath to uphold the Constitution. Maybe she took a different oath. We're discussing a bill today with a title dripping with irony. Do no harm is a preposterous name for a bill that not only directly violates the First Amendment and Americans' freedom of religion, but also blatantly picks winners and losers among Americans of faith. The Do No Harm Act undermines a law that has served to protect Americans from religious discrimination for 25 years. RFRA is not about protecting certain religious groups over others. RFRA applies to all religious faiths, including minority religions. It's a balancing test to ensure a fair day in court. We're entering treacherous waters by considering legislation that stifles proven bipartisan solutions, and more seriously, our Bill of Rights. It's outrageous that Democrats are advertising this legislation as guaranteeing fundamental civil and legal rights when it dramatically attacks those same rights for people with religious convictions. We have a responsibility as lawmakers to defend and protect the United States Constitution and the American people above all else. The bill discussed here today is not only outside the bounds of responsible legislating and mainstream views about religious freedom, it's also outside the jurisdiction of this committee. Our time today would have been better spent discussing legislation on which our committee could actually vote. But if any good was accomplished here, it's that citizens of faith have been alerted. Those who cherish religious freedom have noted that elections have consequences, and those consequences are being manifested in today's hearing. This hearing was intended to review the, quote, misapplication of the Religious Freedom Act, end quote. In reality, it misapplies our role as legislators, tasked with protecting the Constitution by stripping citizens of their fundamental rights. Nevertheless, Mr. Chairman, committee Republicans will continue to stand up for religious freedom and oppose policies that disrespect and diminish the faith of any American. I yield back.
Thank you.
I'm sorry, Mr. Chairman. I ask unanimous consent to place in the record a letter from the U.S. Conference of Catholic Bishops Committee for Religious Liberty in support of the Religious Freedom Restoration Act and in opposition to H.R. 1450.
Without objection. Before I conclude, I'd like to make a few clarifying remarks. The Do Not Harm Act does not create a new affirmative requirement to provide or cover abortion, birth control, or any other type of health care. When Congress does pass laws that protect reproductive health care access, Do Not Harm would ensure that RFRA cannot be used against those patients. Because of several laws limiting coverage and provision of abortion care, the 2016 rule implementing Section 1557 of the Act did not include requirements regarding coverage or provision of abortion care itself. However, the rule did make clear that a woman could not be discriminated against because she had an abortion, and notably, the Trump administration just proposed carving out this protection just as another attack on constitutional rights. I notice the time is just about out, but I would want to remind everyone that the victim in this case is the person trying to get a job or trying to get services without facing discrimination. We're talking about federally funded contracts, not what churches can do on their own. They can discriminate in hiring with their own money. They can do things like that. But if it's a federal contract They ought to play by the same rules that everybody else is. You take the federal money, you can't discriminate in employment, you can't discriminate in who you serve based on protected classes like religion. The services provided on those agencies are under the jurisdiction of this committee, particularly family placement services and others. And so I think the hearing does indicate how these services will be provided in agencies under our jurisdiction. But it's a simple question. In a government-funded contract, can you tell somebody that you're not entitled to a job at this federally funded program because of your religion, yes or no? I don't think you ought to be able to discriminate like that. Others think that there's some value in that. We've been fighting that battle for a long time. I thought we had won it in 1964 and 1965, but apparently we have to refight that battle all over again. With that, if there's no further business to come before the committee other than unanimous consent request to introduce into the record a number of letters and documents and reports, and I'll ask unanimous consent without objection, so ordered, and the committee is now adjourned.